It's 10:05 and we should start. I think this is recording. We don't have important opening speech. It's just me telling you something. You'll have to settle for me today. Okay, today's day is in English completely, so you know that. Let me make it a bit grand. So, welcome to the first day of Belgrade Philosophy Week, which is this year devoted to artificial intelligence, digital technologies, and law. We are starting the week with a student conference, and just any student conference. We've been doing this for 10 years now. So this is the 10th inaugural student conference in Theory and Philosophy of Law that is organized by the Faculty of Law, University of Belgrade. This year is also special, like last year, because it's organized by a Center for Legal Fundamentals that deals exactly with topics like this. The center, formed within the Institute for Legal and Social Sciences, within a great project that we've been working on called the ALF project, Advancing Cooperation on the Foundations of Law. And this year's conference and this year's week, Belgrade Philosophy of Law Week, is organized thanks to the funds of that project. So we'll have a 2-day conference, and I'm very glad to see you all here. The first day will be in English entirely. You'll be presenting your papers in English, and the second day will mostly be in Serbian, as far as I know. Most of this conference is, like every other year, organized by Sava Vojnović and Mila Đorđević in the last couple of years, especially because they have taken over the conference, and I thank them for that. But also by the other members of the younger research team on ALF, Ana Zdravković, Marija Vlajković, and I'm forgetting somebody, Julieta Rabanos, who works with us, Mina, who is always helping as a member of the organizational board of Eudaimonia, and of course, everything that works today is, you should thank them. Everything that doesn't work, you should blame me as usual. This year is also special because the topic of digital technologies and law, we started handling the topic this year. We were prompted a bit by the advances of artificial intelligence, especially generative artificial intelligence, the advent of it happening at the beginning of this year and a bit earlier. But our guests today, and especially our keynote speaker, have been dealing with digital technologies and law for quite a while, more than a decade, I think. And they've been doing research in legal regulation of digital technologies, of new technologies. 10 years ago, maybe it was social networks, but definitely from this year on, it's definitely the topic that we are discussing in this year's conference is the topic of generative artificial intelligence. So thank you all for coming. I hope you have 2 great days of conference, that you'll have a lot of great discussions. Without further ado, I'll leave the floor to our first moderator and to our keynote speaker. The first session will be moderated by Miodrag Jovanović.
Thank you, Bojan. Let me greet you all from my side. I just want briefly to say that there are places at which anniversaries matter more than in some other places, and Serbia is one such place. Why? Because we are here at a place with a lot of discontinuities, with incapability of various institutional practices to get a hold, to preserve in time, and to have a student conference that is making its 10th anniversary. It's really something to be celebrated about. When we started the student conference, this was a fairly revolutionary at the University of Belgrade, not only at the Faculty of Law, because we do not have a tradition. When I say we, I mean in this part of the world, to have student conferences. And for that reason, it is very important that we manage to not only to observe these conferences, but really to make it an international event, which is so evident on this year's program. And what is even more important, and Bojan made a few remarks about that, at some point we made the whole thing speaking in theoretical terms an autopoietic system, meaning the system that can work with being self-referential and from a perpetual mobile system with the new generation of young people that get involved and manage to organize the entire event. So I also want to extend my gratitude to the team who prepared this student conference. And as Bojan said, our today's topic as law digitally tells how old I am. Đorđe Krivokapić, who is now a professor at the Faculty of Organizational Sciences at the University of Belgrade, who is really an expert in this area. So I will give the floor to him, and I'm sure that his presentation will be the best intro into entire conference, not only today but tomorrow as well. Đorđe, the floor is yours.
Thank you. It's my pleasure to be here today. Before I start my presentation, I'll just say a couple of words about my career, because I think it's relevant for you as still students going in different directions. Probably most of you are into academic careers. Just to briefly provide you like my background. Like I graduated here in 2006. I had the great opportunity to finish Master of Law program at University of Pittsburgh in next year, and then I worked a couple of years in law office, working in M&A field, doing corporate work for a couple of years before I had the opportunity to join Faculty of Organizational Sciences, and that really changed my career, because after finishing legal education, I was surrounded by business people working corporate field, and then suddenly I was completely surrounded by engineers, and that was great value for me. Amazing experience to see these different perspectives. And then as business world, quite early in 2009, 2010, I decided to switch to information technologies, and then to approach them from a perspective of business operations, from the perspective of human rights also. So that's kind of a circle which enabled me to have a great overlook over all digital technologies and be able to understand and discuss regulation surrounding them. And today, I'll talk about challenges of regulation of artificial intelligence and advanced technologies. Although it seems that this topic is novel, it's not so much. We have artificial intelligence present in our society 6 decades, that's sure. But it seems that now this is the topic which will stay with us forever and be more and more relevant in all different contexts. So First thing I would like to talk about is what is the future we are looking for. And probably most of you can see here the Huawei cameras you are familiar with because you cross our city on every corner you can see similar cameras. And these cameras start popping up like mushrooms after rain somewhere in 2019, just before the COVID pandemic. And at that moment, we found out from a minister of Interior at that moment that it's a great project, it's a safe city project, it will enable us to make our society completely safe. We will know who came from which entrance, who entered which car, we'll be able to follow everyone, all the criminals. But there's one big problem with all these statements and ideas and visions, because based on a paper, based again on documents and of our government, we already live in a safe society. And there are not so many criminals surrounding us. And now we are establishing a system of 6,000, 7,000, 8,000 cameras around the city, which all have various advanced capabilities to identify persons based on biometric identification in real time, to process different analysis of behavior of people, to establish patterns of our behavior, and so on, based on advanced technologies and artificial intelligence, impacting our social contract on so many levels. Privacy. It is fact that we have the right to privacy even in a public space. For example, police cannot identify us according to the law on police without having a justifiable cause for identification. So we should be private. We should have right to our privacy even when we are walking around the city. But there are so many other rights which are impacted. For example, right to protest, right to assembly, right to free speech. If we are always surveilled by the government, the rights we obtained during the 20th century do not have the same value as before. So it's just the example how implementation of technology can really impact our social contract and our expectation of our future behavior. And at that moment, it was really hard to understand, is there any option how to block this system? Because it costs, we don't know how much, because there are no any transparency in the process, but it's estimated around 200 million euros, the whole system. It's our money, and no transparency of the process and no justification. However, there are some people in the civil sector supported by different activists who really started different procedures. And at this moment, this system doesn't work according to the purpose for which it was established, because there is no legal basis and there is no compliance with the law on data protection. So until this moment, the system is blocked. But what is this story, again, providing to us? First, that we are all under the pressure to implement digital technologies and AI, especially the managers on different levels. We are all offered with different solutions to make our operations better, more efficient, less costly, and so on. But we are not really aware of the risks these technologies are imposing on us and society and economy. And there is no legal certainty that we can apply these technologies. So it's really necessary to set different boundaries when implementing technologies. Of course, it's relevant to ensure legal certainty if we invest into technology and new processes, that we are sure that we can really apply those and get the benefits. But also, we have to find a way how to protect our fundamental rights, because technology is not neutral and technology can impact them. So really understanding this impact is critical. In that perspective, we need to establish this ethical application of artificial intelligence, taking into consideration wider interests, for example, impact on environment, also impact on organizations and so on. And we still need to build a system which improves trust, because without trust into technology, there is a really low potential for all the benefits we expect from the technology. And what's the problem is that we are at the age where artificial intelligence and natural intelligence, our intelligence and humans, are coming to the point of singularity, the point where we can expect that machine intelligence, artificial intelligence will be more efficient and better than our own. So we never been before in situation to regulate something bigger, stronger, and more intelligent than us. Maybe we were regulating state as a concept, but state was still created by the people. And here is this main dilemma. How do we approach artificial intelligence? Is it the agent, the personality, which has its own will, its power to reason and decide, or it is an object, the person? And although there are many theories and arguments that we can have artificial intelligence, and that we can maybe even impose legal and ethical norms directly to artificial intelligence, and then wait for its reasoning to decide how to behave according to these norms. It's still tricky to take this approach. So we still look at artificial intelligence as an object, as something under control of the individual. And our current regulatory approaches are on that position. But what's a common understanding of regulation in the field of artificial intelligence, that artificial intelligence and advanced technologies are not regulated at all. That's something what's running out of the sphere of regulation. However, when we took the legal and ethical landscape and tried to analyze what fields can be applicable, we can see that there is a lot of intersection there. And first, we have a general regulations in field of civil law and criminal law. And if your machine, if your self-driving car hits someone, there is clear obligation to pay damages which were imposed by that accident. If you hit someone so hard that he takes like physical injuries or maybe dies, there is criminal liability. So on a basic level, all these behaviors are regulated by general regulation norms. It's hard to establish direct accountability of different actors in a value chain from producer of artificial intelligence to the owner and final user, but you can apply these basic concepts. On the other level, we have sectoral regulations, for example, telecommunications, energy, medical, and so on. And in these sectoral laws, we can find specific norms regulating specific situations of use of advanced technologies and sometimes artificial intelligence. This is approach which is common in areas where you really have high penetration of artificial intelligence and advanced technologies, and you have some critical infrastructures you need to protect. However, it's still low, especially in our country and a region, and it's not the approach we will see further developing so much. Then we have horizontal regulations, which are somehow applicable to any use of artificial intelligence. It's different approach. It's not related to the sector. It's related to the basic values which are protected. And then we have, for example, anti-discrimination regulations, data protection, information security, and so on. And if you have artificial intelligence system processing some data, then if these data are personal data, you need to apply fully data protection regulation. If there are like data which can lead to any type of discrimination, you have to take into account anti-discrimination regulation and so on and so on. So these areas are covered, and thanks to this approach in Serbia, there was capability to stop 1,000 cameras system I explained before. And then we can approach artificial intelligence per se and appoint specific regulation to it. We don't have it at the moment in Serbia, but there are some regulations which are awaited for quite some time, and we can expect some of them until the end of the year. I'll talk about that a bit later. Then, on a lower level, we have ethical codes. Ethical codes are very popular. We are facing some new risks, some new developments in society, and before we impose hard regulation, we try developing softer rules. And in the last 5 years, there is more than 100 different ethical codes applicable to artificial intelligence with different approaches and so on. And then they can be applied in various sectors or for different types of operations. It's implemented in internal policies of most of organizations are implementing internal policies about the use of generative AI, how employees in different positions can use ChatGPT and for which particular purposes, under which safeguards and so on, and I think what is regulated on that level. And then at the end, we have technical rules, principles, which are applicable to technology by developers and which are as standards not so common to us as lawyers. From the regulatory point of view, we have two documents at this moment as very specific. Those are ethic guidance for trust by European comprehensive document applicable to all companies in European Union, but without any lead enforcement mechanism. Based on this document, which provides very useful recommendations, our government some months also adopted ethical development and use of intelligence. So even in Serbia, we have a clear document in that respect. And then when we take a look over the whole landscape, there are like different types of sanctions we can see coming out of this area. First, we have, if there is some damage, we can talk about damages. If there is a breach which has a consequence on the of legal persons based on classic damage theories, somebody who is responsible for that damage has to pay. Then we have regulatory non-compliance, for example, in field of data protection or anti-discrimination in some other fields. And there are many cases quite relevant which provided either that regulators see the use of the or different sanctions, regulatory fines which have to be paid into the budget. And then there is reputational damage arising out of these ethical norms. So there are like 3 different types of consequences at this moment. However, the main question is really, is it enough? And discussion around the globe at this moment is, regardless of the fact that we are exploring how to apply all the existing regulation which I presented to the artificial intelligence and advanced technologies, and we are exploring that field and opportunities. There is ongoing discussion, still figuring out, is it enough, and how we approach these novel uses of artificial intelligence. And when we approach this question, there is an issue: does the law speak? Do we have the regulation in place? And as I explained, there is a regulation. Then the next question: is there a satisfactory answer to the problems we are facing? And if the satisfactory answer is yes, we'll just enforce it, put more capacities in monitoring and enforcement to resolve the problem. However, that's not the case. There is no also easy fix based on a Brussels discussion. Brussels and EU came to the conclusion that there is a need for legal disruption and harder regulation, which will completely change the landscape and introduce the new rules in the arena. These new rules have different options. Again, code of ethics, not well. Voluntary labeling schemes that each producer and user of artificial intelligence provide transparent explanation what he is doing, still not sufficient. Then sectoral ad hoc approach as an option, that we continue developing sectoral laws in a way that each one of them regulates artificial intelligence in this particular sector. That's very burdensome, requires a lot of time and a lot of regulatory changes in different legal acts. Brussels decided not to take this route. However, United Kingdom decided to take this route, and we'll see more of this approach in UK. What EU decided to follow is horizontal risk-based approach document, so-called Artificial Intelligence Act, AI regulation. It's, of course, the document on the level of regulation, but they called it eventually AI Act in order to sound more like a law, because European citizens have to feel it better. What is the approach of this law? That it regulates artificial intelligence systems. And it has a human-centered approach, so protection of fundamental rights is one of the priorities. Also, it's compliance and, let's say, business regulation. And the main characteristic is that it has risk-based approach with ex-ante conformity. What does it mean? It means that the rules for compliance will be established based on a risk particular artificial intelligence system imposed on society. More risk, more obligations in compliance process. Ex-ante conformity means that regardless of the fact did you impose any damage and breach any rights of users, you will be liable and pay the fine only if you did not comply with the process. So there is no need for damage and breach of rights in order to be accountable. Accountable in a way, and that's important, to pay sanction up to 30 million euros or 6% of global turnover of corporation. So this high sanctions is something what we didn't see before, not even in EU competition law, for which EU was established. And we saw these examples in Data Protection Act, where we had sanctions up to 20 million and 4% turnover. And just to be clear, in the last couple of years, we had a couple of decisions going, one particular going up to 1 billion euros. And EU already collected several billion euros based on these regulatory fines. So there will be opportunity for this for more sanctions in this area, and this is something what is really waking the management of companies to comply with this set of regulation. Who is point of regulation? Many providers, the makers of artificial intelligence systems, but all the users, distributors, traders also. And let me just, I have just two main points. First one is that there is also hard to define artificial intelligence system, and when European Commission proposed the document, first draft 2 years ago, it provided one definition. Now we are in final phase of trialogue, and let's say that we should have the act until the end of this year enforced, and then we'll have 24 months period for implementation. But they defined artificial intelligence as a software based on different techniques, and here is the list of techniques, which included machine learning techniques, logic knowledge-based approaches, and statistical approaches. Not so relevant for you at this moment, but based on software which based on these techniques and given set of objectives generates different outputs such as content prediction, recommendation, decision, influencing their environment. What was the main critique of this definition is that these techniques and approaches are very wide, and that even, to make it quite simple, even Excel table providing different outputs could be classified as AI system. It's very, very wide. And then in a trial discussion, there was we can see now the new definition, which talks about machine-based systems. Artificial intelligence systems are machine-based, and what is relevant that as a new definition with varying levels of autonomy. So the most important concept which is developed is that these systems have the autonomy when creating outputs such as predictions, recommendations of the system. What is it's simple for you now to understand. If you use ChatGPT, you can put one request, one prompt, but based on that same prompt, you will get different outputs every time, because there is autonomy of the system to create something different. When you have a system which always for the same output provides the same results, for the same input provides the same output, when there is a mathematical certainty in the operation, it's not artificial intelligence system. Only the systems which have autonomy to create something different. For example, when we talk about generative AI in visual field, DALL-E or Midjourney, you put one prompt, you get 4 different images. They're all the results of the autonomy, and then you choose which one you want, and so on. So this autonomy is a risk, and risk has to be regulated with quite specifics. So at the end, how the approach to regulation will look, we'll have to identify all artificial intelligence systems and products based on AI, assess the risks toward not only human security, like in the cases of other products, but also toward fundamental rights, environment, rule of law. That's all inserted within the AI Act. And based on these risks, classify AI systems on 4 levels. And then depending on which level is the system, is it too risky, with high risk, low risk, or no risk, it will have a different route. You'll have to design this AI system in line with the requirements. There are like 10 different requirements, quite technical. Then you have to perform conformity assessment to assess that the system is designed according to these requirements. Register AI system within the authority, then a fixed C marking, which is the trademark, which will allow you to put it on the market, and then to implement and determine roles of different actors who will implement and use the system, and then do continuous monitoring in order to assess other risks which have not assessed at the beginning. So I'll stop here and just conclude that it's different model than we had before. It's a model which does not have clear norms applicable to clear situations, but it's really case-to-case regulation, where depending on the risks, there are different obligations of the actors who are using and developing the technology.
Thank you, Đorđe, for this really comprehensive overview of the state of art in this area. As you can all figure out, we are really in a process which can metaphorically be presented as taming the wild horse of artificial intelligence. There are different strategies how to tame it, but one of the bigger and deeper and more philosophical problems is really how to comprehend what is happening. I would just give an example from the last part of Đorđe's lecture. We are struggling to find adequate concepts which can correctly depict the problems that we are dealing with. So when we are employing the concept autonomy to describe the artificial intelligence, we are obviously making a kind of anthropocentric approach to the subject matter, because one of the things that is a big mystery is really how it comes that each time that we put the same prompt, we get a different result. So that's one of the big problems of the artificial intelligence that is well known among the scholars as the AI delusion. So you can get a delusional answers from these prompts, and this is obviously something which we have to deal with, especially having in mind that our first idea was to get an aid in our human world which will somehow eradicate all our failures, biases, and so on and so forth. We are not getting that. We have a more complex picture, and now it's time for a brief discussion or a series of Q&A, although it was not provided in our schedule. I think it would be good to start with a couple of questions and comments just to warm up for the following sessions. And this goes also, the call for Q&A also goes to our online participants as well. So please let us collect if there are comments and questions, and then Đorđe will answer. And if you are making questions, please use the mic. Oh, okay, there are a couple of questions. Let's start from the students. Yes, go ahead. Just introduce yourself and use the mic.
Hello, my name is Nikola. I have a question. You talked about internet privacy and AI regulations. Me and my colleague Anja, she's not here right now, are writing a paper about internet cookies, and I would like to know what could you say about them and maybe give us some advice. Thank you.
Go ahead, the next one, Sal.
Thank you, Đorđe, for the great presentation. Just a brief question, perhaps on the more detailed account of regulation, which you perhaps find most acceptable in the field of autopilots, automobiles and trafficking. As far as I understood, there are different types of regulations for different types of programs and AI systems. So that's it. Thanks.
Thanks. Yeah, of course.
I was wondering whether the problem about self-regulated cars is that the software cannot be qualified as a product, neither in Serbia nor on EU level. Thank you.
Thank you. Go ahead, Mila.
I also have one really practical question. What are the borders of using artificial intelligence in academia? Since we are all writing the papers and we are in process of writing ones, we have a possession of ChatGPT, what we can do and what we cannot do when we are drafting our final versions of the papers. Thank you.
Thank you. Jules, you all? Yes, please.
Well, thank you very much for the presentation. I wanted to go back to what you said about autonomy and then also something that Nieto asked. What is exactly autonomy in this context of AI, in the sense of we know what autonomy means for example, human beings, but what do we think when you say that AI has autonomy? Thank you.
There were also some hands. Oh, okay. Please.
Thank you, and thank you for the lecture. So, giving everything you've said and viewed from the lens of both law and organizational sciences, what is the next domain of social life where we can expect the use of AI? In other words, where would it be essential the most at this point? Thank you.
Thank you very much. Are there any questions from our online community? Not at the moment. Okay, go ahead, Judge.
So I'll try to be brief because there are many questions here. Regarding cookies, just in a couple of sentences. Cookies are the area which really started developing AI on a large scale because it created infrastructure and data for development. And really targeted advertising connected with the cookies is first really applied artificial intelligence, which completely changed our world because the way how we receive the content online, regardless is it advertising or the content on social network and so on, it's all managed by artificial intelligence, not by human editors. So that enabled completely different business model, and that enabled like the new companies and new models for regulation of content. However, there are like different levels from e-privacy regulation, which have to be updated, to GDPR, which regulates that particular field, to now Digital Services Act, which came into the force and has some impact also in this area. So there are different levels of European regulation, and AI can be also applicable on the field later on, not to cookies per se, but to use of data created by cookies. Autopilot and self-driving cars. So in general, this approach provides the same rules for the artificial intelligence used by self-driving cars or artificial intelligence used in a student department of law faculty to do the transcripts of our audio conversation and create some content for something else. So regardless of the field of use of artificial intelligence, the European approach is the same. We assess the risk. If the transcripts will be just stored in an archive, the risk of a mistake is quite low. So maybe we'll not go the whole process and all the steps I showed. While if the risk is human life, then there'll be so many steps. However, that relates to your question. The whole system is system of risk assurance and quality assurance, which is already imposed in all the fields of seen as a product. Of course, it's not only the software. When we talk about artificial intelligence, we talk about different levels of data, training data, input data, and so on. Then we talk about algorithms, models and algorithms processing this data, and then we have this part which has the interaction with the environment, either digital or physical. So it always is composed of different elements. Some of them are software, not all are software, and that's why we have the new definition which says machine-based systems, and systems as a complex systems is the idea. So when we talk about the use of and maybe to answer autonomy and then to go to specifics regarding autonomy, that's a big discussion at the moment. We have to find the proper definition of autonomy, and now there are like a couple of different approaches. How first is varying level of autonomy, and it's really the new definition which is now discussed says artificial intelligence systems can have smaller or bigger elements of autonomy, but they have to have autonomy. But what is the threshold of autonomy to be artificial intelligence? That's the first question. But the new definition also has a sentence that artificial intelligence systems infer, they think, they reason. So they reason with autonomy. So it's one of the big discussions, and we will have some definitions, but I really think that the court practice will really establish what is and what is not artificial intelligence when in 5 years we'll know that. When we talk about use of AI, ethical use of AI in our work, regardless is it academia or something else, I would just say there is only one rule. You can use artificial intelligence for the task you are able to perform yourself, because the main principle of ethical use of artificial intelligence is human oversight. So you have to be able to do human oversight and quality control of any output which goes out of any artificial intelligence. In particular, we talk about ChatGPT. So if you can do it on your own, if you're capable to perform something on your own, then you can use artificial intelligence, do human oversight, do quality assurance, and then use the output. Because in order to be able to create something what is worthy, you need to know all the elements. Otherwise, you can go into a deep hole with a lot of risk, creating something what you don't understand, and it doesn't mean anything. So the main principle is the question of transparency. We have to be transparent about the use of artificial intelligence. That's the second principle. And if we use ChatGPT in writing of our article, we have to be transparent about that. If we use it on a larger scale, again, what is the threshold? It's a great question. If we write the passage, then put into ChatGPT and ask him to make it more sound academic because our English language is not amazing, then we would say it's a minor use of artificial intelligence. It's the same thing as you use the lector and translator. So it goes back to basic academic rules. Are you the creator of that idea? Are you able to really process all the inputs and create this new idea? Or the new idea was the result and output of artificial intelligence. So if it's result of artificial intelligence, that it's not your idea. However, there is no plagiarism applicable here. We have to adjust rules on plagiarism because plagiarism is generally based on taking either somebody else's content or ideas. Here, it's not clear whose ideas there is. We have to find another ethical breaches in academic environment and figure out how to establish them and create mechanisms for monitoring and sanctioning. That's not easy. And then your question is very interesting, but very wide. Like, what are the next areas? Like we work quite a lot with different sectors, and all the sectors are under high pressure of implementing AI from organizational point of view, because, for example, my colleague Ivona and me, we work a lot on in a field of human resource management. It's really a question which functions of humans within the organization will be replaced by artificial intelligence in next 2 years, and how we will develop new organizations mixing human and artificial intelligence. So we have to do restructuring of all the processes and all the organization in the next couple of years to create the new system. Why? Because all the organizations want to be competitive and they don't want to lag behind with non-optimal operations.
Okay, thank you, Đorđe. I think that it was worth it. I mean, we are now 20 minutes lagging behind, but it was definitely worth it. So let's give another round of applause for our keynote speaker. And now we move to the first session, in which we will have Dušan Samardžić from the Faculty of Law and Ivona Živković as commentator from the Faculty of Organizational Sciences. So please do join me here. While they are coming and joining me for the presentation, just going back to the question that was put by Mila, how to regulate and how to restrict the use of artificial intelligence in our academic work, since you are all here at one academic event. It was an interesting story from the beginning of this year. So the article was published in the beginning of 2023, and the title of article was "Chatting and Cheating: Ensuring Academic Integrity in the Era of ChatGPT." So it was dealing with this problem, but the tricky point is that nobody knew, neither the reviewers nor the readers, that the article itself was written by ChatGPT. So it went through the entire reviewing process. It went in the journal, and the authors just subsequently revealed that it was produced by ChatGPT. So obviously it's not easy to wait and to reveal the whole thing. Okay, now we are moving to the first session. You know the rules of the session. So 15 minutes of the presentation, 5 minutes of the comment, and then 10 minutes of the discussion. So we have very precisely half an hour per session. And the first topic is really interesting, or at least the title is interesting. I'm looking forward to hear the content. Deleuzian perspective on the right of data protection on social media. Dušan Samardžić, the floor is yours.
Okay, thank you very much. So, as mentioned, the topic of my paper is a Deleuzian perspective on the right of data protection on social media. So, the main objective of this presentation the analytic framework for understanding the ways user data can be exploited today and see some recent attempts to protect said data. I have done this by contextualizing the concept of surveillance capitalism within Deleuze's theory of controlled societies, which in turn is based upon Foucault's analysis of power. So, to begin with Foucault, he identified two broad ways societies were organized in the West in relation to how power was exercised. So, sovereign societies, on the one hand, dominant in antiquity and the Middle Ages, broadly speaking, were characterized by the taxation of production and the sovereign's right of life and death, while disciplinary societies, which evolved after the French Revolution, organized production and administered life. So, what does this mean? Mere taxation was based upon the principle of deduction, which meant that the ruler had the right to take a portion of his subjects' wealth without interfering their production process. On the other hand, in disciplinary societies, production is organized in a way that maximizes efficiency. The subject is told how long does he need to work, in what way, what techniques to use, etc. Secondly, while sovereign societies ruled over death, usually utilizing the death penalty as a retribution against the transgression of the law, which was seen as the will of the sovereign, disciplinary societies not only control death but births as well, by controlling birth rates through population politics, etc. Building upon Foucault's schema, Deleuze claims that we are presently witnessing another shift in the way power exerts itself upon individuals. A major shift was in the analysis of open spaces instead of enclosed disciplinary spaces. Before, in disciplinary societies, individuals always started all over, from the school to the barracks to the factory and so on, which Deleuze called molds, that is, fixed spaces created, enclosed spaces to shape individuals. But that is no longer the case, since the individual is never finished with anything, but is in a constant state of development, that is, modulation. As he put it, what has become confined is the outside, the virtual, which is done through a periodic regulation and capture. Before, enclosed spaces served the purpose of picking out one possibility out of infinite virtualities. Disciplinary institutions, thus, were not only repressive but also productive in the sense that they created subjects. In contrast, controlled societies became open and power permeates throughout the whole of the social sphere. From there, we see that the group has dissolved first into individuals, but for Deleuze, this is only a stepping stone, because Foucault stressed the importance of the mass, that is the group, in shaping individual subjectivity and vice versa. However, the corporations in controlled societies do not strive to achieve that level of control, but rather seek to manage only a specific part of the market that pertains to them. Due to the modulating nature of the social institutions, individuals have become less stable as a category, since their utility changes with the shifting nature of said institutions. As Deleuze put it, in societies of control, what is important is a code. The code is a password. So individuals as a whole no longer play a pivotal role in interacting with different social systems, but rather only the individual's representation, their behavior as a consumer is what it counts. Deleuze coined the term dividual. Now, a dividual then is a different source of information depending on the institution you're interacting with. For example, to the bank, your credit score. On social media, the preference of the type of content you consume, and so on. The individual is turned into a multiplicity of data banks. This is in part a consequence of the change in material conditions, where capitalism is no longer involved in production, which is often relegated to the third world. There's no longer a capitalism for production, but for the product, which is to say, for being sold or marketed. Finally, we come to surveillance capitalism itself. So Shoshana Zuboff defines it as a new subset of information capitalism, whose primary goal is to predict and modify human behavior as a means to produce revenue and market control. the notion of big data, Zubov claims, is not just some autonomous process of digital technologies, but an immanent part and the object of commodification within the system of surveillance capitalism. Instead of computer spheres of social life, many of our actions become visible and accessible. But Zubov asks the question, to whom is this data accessible, and who contours the boundaries of said data accessibility? So Zubov sketches the ways new capital accumulation is performed, and she points out four trends, I guess. One of the main characteristics of surveillance capitalism is its appetite for data collection and analysis, data analysis. The second point, new contractual forms due to better monitoring, we shall come to it a bit later. And thirdly, personalization and customization. This characteristic refers to the way algorithms predict what the individual needs to know, sometimes even before the individual itself knows it. For example, in 2018, it came to light that among its myriad of algorithmically determined advertising categories was an entry for about 65,000 Facebook users whom data mining systems believed might be interested in treason against their government, which does sound a bit comical, but considering the fact that, for example, the Serbian government, compared to other Western Balkan countries, sends the most requests to the company Meta, that is Facebook, for insight into users' data with about a 75% approval rate from Meta. Then from there we can see some problems can arise. Then, in what way is surveillance capitalism compatible with control societies? Well, I would like to point out three, I guess, points. First, in terms of the main actor in the new architecture of surveillance, both Zubov and Deleuze agree that private enterprise plays a bigger role than the state, and that state power is to be understood separately. Secondly, and probably most importantly, in terms of the object of control, that is surveillance, Deleuze points out that the concept of the individual points to the fact that subjects no longer interact with the system as a whole, but as a multiplicity of data banks. Various digital footprints that the user leaves on social media and the internet generally together become his or her representation. From there, one can connect Zubov's analysis of big data to control of societies. Thirdly, the change in the frontier of control. For Zubov, that is overcoming the unknowability of the market, which used to be postulated by various neoliberal economists. And for Deleuze, this is the breaking down of disciplinary institutions and the spread of surveillance and control throughout the society. Finally, we shall briefly analyze some of the most progressive legislation in the world concerning these questions, that is the EU data protection legislation. So in 2017, the European Parliament passed a resolution which defines big data as the collection, analysis, and the recurring accumulation of large amounts of data, including personal data, from a variety of sources, which are subject to automatic processing by computer algorithms and advanced data processing techniques, using both stored and streamed data to generate correlations, trends, and patterns. From this definition, we can infer a formula. That is, the more data there is, the more precise the results. The results are never a consequence of only one data point, but of a network of data. Because most of this data is unstructured, it is difficult to find the exact origin of the data used for analysis. It is therefore difficult to connect the purpose of the data extraction and the consent of for its use, which is one of the greatest difficulties of data protection today. Then finally, in 2018, the General Data Protection Regulation came into force. While the GDPR itself does not contain a definition of big data, it does, however, mention profiling, which is, according, if we follow the previous definition, is a subset of big data. And so Article 22 states that the data of the data subject cannot be automatically processed. However, there are three prescribed exceptions to this rule. and we shall focus on the first one, namely that the rule does not apply if it is necessary for entering into or performance of a contract between the data subject and the data controller. The said standard of necessity is also not developed in the regulation, so it will probably be left up to the courts to flesh it out. However, for Zubov, this is the antithesis of the classical notion of the contract and the rule of law. Consensual participation, she writes, in the values from which legitimate authority is derived, along with the free will and reciprocal rights and obligations, are traded for the universal equivalent of the prisoner's electronic ankle bracelet. The contract has become a method for forfeiting privacy for something in return, such as a mortgage, medical advice, legal advice, or advice from a personal digital assistant. However, at this point, only a few years after the regulation came into force, it is still quite difficult to say what effect will this have on the big data industry, which definitely is already in full swing. And also, this will be again something that I will try to further investigate in while I write my finish my paper, as this is just the first draft, and if I can even call it that. And all in all, in conclusion, given the fact that the trend of control societies of commodification of flows of data have proven to be immensely profitable, it seems unlikely that any number of lawsuits or new regulation would entirely undermine this new logic of accumulation, and since abandoning it entirely would mean the end of the present economic system as we know it. So thank you for your attention, and that's all.
Okay, thank you, Dušan. Dušan was the icebreaker, so obviously he was a bit concerned about using the time. This is something that you will learn in the process of presenting in these conferences. So you kind of managed to do it in less than 15 minutes. So this will leave more time for discussion. Now it's time for our comment, and it's time for Ivona to give her comment. Please.
Okay. Hello everyone. Thank you for having me here today. I think that your paper is very interesting. It's good, but I of course have a few comments. I will start with my overall impression on your paper. In some points, I had the impression that I was reading two different papers. The first one is theoretical framework, and the second one is the analysis of GDPR. I think that you should try to draw some line and to make solid connection between theoretical framework and the analysis of the documents. Also, I think I will start with introduction, if we can call that part introduction. Yeah, historical, you know what I'm talking about, historical background. If that part is introduction, I think that you should list some key points of your paper and to introduce us with what is going to be written in the following rows of your paper. When it comes to analysis of Foucault's theory, I would say it's very good, but it's a little bit too long. You have almost 3 pages out of 9 pages about analysis of Foucault's theory. To be more specific, first chapter, Societies of Sovereignty, I think it's too long. You can try to sum up that chapter in 2 to 3 sentences, just to point out this transition from one type of society to another one. That's enough. Another
comment is that this part you should put more emphasis on this part methods of disciplining. I think it's very important for the topic of your paper. Also, the part where you are talking about or writing about surveillance, especially in the context of the social media. I think that part it's also very, very important, and that you don't put enough, I would say, attention in your paper on this part. Also, at the beginning of every chapter, you should provide us with some, I would say, information or again, some kind of introduction, one sentence just to say to us what you are going to present in that chapter and to make some kind of link with the things that you were writing above. Also, you need to be more careful with references. In part of paper, especially third chapter, I will quote now, you said specifically the most influential attempt to at protecting data is the European Union GDPR. Okay, it maybe is the most influential attempt to protect data, but you need to put some reliable source after that sentence. I can send you paper with comments on topic course. And at the end, the conclusion, if again that is the conclusion, I think, yeah, it's okay. Again, I would say that it's too short. We need to have some kind of solid conclusion when you are going to make solid connection between theoretical framework and the analysis of these documents. You need to be more clear, and overall, I would say my greatest, not greatest, but the main complaint is that you should make some connection between, or the solid connection between theoretical part of the paper and the analysis. The only part where you are doing that is when you mentioned that in your presentation, that when you are mentioning Zuboff theory in the context of analysis of some contracts, right? And none of all other theoretical frameworks that you mentioned in your paper. I think that I was okay.
Thank you, Ivona, for this comment. So now for all of you who here for the first time and who are firstly introduced with the overall framework of the conference, you can see how basically this functions. This was exactly the type of comment that we are looking for, and now it's time for you also to take participation in this discussion and to ask questions or make comments to Dušan, and then he will eventually respond to commentators' criticisms and to questions or comments from the audience. Đorđe?
Thank you for presentation. Just brief comment, more like a suggestion, because my colleague Andrea Nikolic and I, we just finished the paper on the relationship between profiling, automated decision-making, and artificial intelligence, and trying to figure out how they overlap. And in the context of your paper, because you're going after profiling, but in the context of automated decision-making, would be helpful to understand, to go more and understand these concepts altogether. And the paper will be presented in Kopaonik in 2 months, but we can send you the paper. So something just to take a look, because these concepts, because you struggle with concept of big data, profiling, you didn't introduce automated decision-making, but it's all together. I don't like the concept of big data as it is, as involved in a theory more, because it's hard to explain. It just has a lot of data, big volume, veracity, and everything. And it's not legal concept, as you explained. So maybe to think about other concepts to reduce the use of that particular concept, which is just the mesh of everything. But just that. Thank you.
Thank you, Đorđe. Any other comment? I don't have to repeat that the same offer for comments and questions is given to our online participants. So just jump in, please, because I cannot follow everything on the screen all the time. So just jump in if you have any question or comment. Okay, if we do not have it for now, I will give the floor to Dušan to address some of these criticisms and maybe Đorđe's comment.
Okay, first of all, thank you for your comments. I believe that they will be very valuable in my further development of my paper. Yes, some of them I anticipated, since yes, certain aspects of it I kind of just try to touch on, and I really planned on developing them later on. Yes, concerning especially as concerning the various notions of profiling, big data, and so on. There, I guess the relationship is very important and very precise, and yes, I intend on developing them further. And also, yes, when it comes to connection, yeah, I also will work on, I guess, connecting theory with practice, as that is, of course, one of the main objectives of my research. And yeah, so that's that for now.
Okay, thank you very much. So if there are no other questions and comments, let's give a round of applause for our first participants. Thank you very much, Dušan and Ivona. Now we move to the second panel, Nađa and Jovana. Nađa, Aleksandar, and Jovana, sorry. Nađa and Aleksandar are from the Faculty of Law, University of Belgrade. They will present the paper Regulation of Influencers. And Jovana is from the University of Kragujevac, and she will act as a commentator. So please join us here. We will find enough space, hopefully. Or here, whatever, maybe there, yeah.
And just a brief remark, there's water on the table. Feel free to take it.
The other general remark, since most of you participate for the first time at conferences, you should really kind of, this is a good place to learn the actual purpose of a scientific conference. So it's not that you come with the final product, deliver this to the audience, and then you leave home. You go home leaving it with the self-satisfaction. That's not the real role of the conference. The role of the conference is really to test your own ideas, which means to subject it to the criticisms, to the scrutiny of the arguments of the audience. So don't be afraid that you will have kind of the response of that sort. It's quite natural, it's normal, and it's beneficial for the authors to give to get as many criticisms and critical remarks as possible, because by the end of the day, which will improve your paper, because conference is one thing, producing a paper is a second thing, it's another thing. So hopefully anyone who presents here will eventually write the entire version of the paper, and this should be seen as an opportunity to collect as many useful comments as possible. So with this in mind, I give floor to Nađa and Aleksandar. They will probably they know how to organize the time between themselves. You have 15 minutes, and then we move to Jovana's comments.
Hello, everyone. Today we will talk about regulation of influencers. To start this topic, we should first answer a question. What is an influencer? Influencer is a person who has power and ability to influence potential customer of some products or services through marketing or recommendation on social media. Influencer marketing replaced pop-up ad era of marketing. Pop-up ads had some really big issues, like being easily avoidable by using ad blockers and causing frustration to potential customers. To continue this topic, we should take a look at brief history of influencers in Serbia. In Serbia, influencers were recognized in 2015 by big companies. Fanta was a big company that gave sponsorship to some YouTubers and sponsored biggest influencer event of that year. Before that time, we have some sort of proto-influencers, and that were some bloggers and early YouTubers and influencers like that, but they hadn't power to influence many customers at that time. Now we will talk about of influencer in Serbian legal system. When we are registered activities, we can choose between a limited liability company or entrepreneur, depending on the influencer's needs. Now we should ask question, what is better? Theoretically, we can give simple answer. In our opinion, LTD is better for someone who wants to create big business because they are responsible with LTD's property, not with all of property of his own. Entrepreneur is maybe better for someone who wants to be self-employed. But this is theoretically easy answer, and in practice we cannot say that easy what is better, because influencer cannot know how big they can grow, and their plans maybe can change through years. Now we want to talk about some specific groups of influencers. First of all, we have children influencers. In our legal system, children can work after age of 15. Before that, children cannot be in a working relationship, and that can cause some trouble with registering influencers and maybe using kids in some really bad terms. Another thing we want to talk are animal influencers. Animal influencers are easy to define because in our legal system, animals are the owner has every right of animals, and animals are treated as property, and owner is responsible with basically everything. And we will want to talk about AI influencers. We have some really good presentation earlier about AI, and we don't need to give much attention about that in that regard. AI is for now treated like tool in AI in influencer world. Now we want to talk about copyright. Copyright is original spiritual work of author expressed in certain form, no matter of their artistic, scientific, or other value. Their purpose, their size, content, and type of expression, and also permissibility of publishing their content. We should ask question: what influencers work? Are influencers work under copyright protection? Shortly, we can give an answer, and that's positive. Most of influencers' work are under copyright protection, but we should pay attention about some other neighborhood rights here. Because we don't have time, we will only talk about performance rights. But before that, we want to mention co-authored work. Co-authored work are specific because influencers tend to collab and make co-authored work and co-authored videos and things like that. And that can cause some legal troubles if they aren't negotiated their how they'll split money and basically property part of copyright. Performance rights are interesting right now because we have growing popularity of platforms like TikTok, YouTube Shorts, and Instagram Reels. And that's interesting because most of them tend to make short videos and perform different dances and things like that in their video. And that can be interesting because we should pay more attention on performance rights. How different platforms recognize copyright? All of the platforms recognize copyright law of the states, but some platforms are more efficient in deleting copied work than the others. Now we will talk about content control. How much can company ask from influencer in terms of costs, contact, etc.? Basically, we think that states shouldn't be involved. The state should be is involved as small as possible in negotiation between companies and influencers, and we have some standards that we will discuss later. And we should talk about one more specific thing, and that is when influencer have copyright and when is company owner of the copyright. In our mind, influencer should be owner of copyright when he is author or she is author of the work and implement ad in their work. If influencer is just an actor in some ad, influencer shouldn't be owner of copyright. Nađa will continue with influencer contracts.
Thank you. So now when we talk about the influencer contract, I first want to say this is an unnamed contract, and in our paper we talked about some key elements that we think should be included in the contract, but here we're going to talk about potential issues that can arise with such contracts. So first, we feel like there could be a contractual imbalance and negotiation from strength, especially coming from the brand or a company. They could put an influencer in a bad position, but also there are possible disputes between the parties. We think those disputes came because there is a lack of clarity in defining responsibilities or content approval or intellectual property rights and such. So the question is, how can we overcome these issues? Well, the first thing is the contract should not be structured as take it or leave it contract. We feel like it should include all the mandatory key elements that would address the core aspects of the collaboration. Also, the both contracting parties need to have the opportunity to add clauses that would meet their specific requirements and needs. We here think that the solution would be standardization, but I will get back to that later. Now let's talk about the Federal Trade Commission, or FTC, which is a model of regulation in the United States of America. So first of all, FTC is an independent government agency. Its main mission is to enforce civil antitrust law and protect consumers. But what's valuable for us are endorsement guides that have been added in 2009. And basically these are guidelines in how to maintain transparency and how to indicate advertising. They're very specific and they really go into the detail. But let's look at some of the sanctions that FTC can impose. First of all, some of them are financial penalties, which is the most common one, but they can also demand reimbursement of funds or prohibit further collaboration between the brand and the influencer. The more interesting one is ASA, or can I just ask for this is a model from the UK. This is a really great example of mixture of self-regulation and co-regulation, where ASA is an independent self-regulatory body that's funded by the marketing industry, but they have a memorandum of understanding with the Ofcom, which is the Office of Communication, which is a government-created regulatory and competition protective body. So what's the purpose of this memorandum? Basically, when influencers or brands fail to adhere to ASA decisions, Ofcom acts as a legal safeguard. It can impose some, it can take legal action. So why is it important to establish such specific guidelines and rules? First of all, when you said the more specific your standards are, the better you are and more efficient in protecting consumers and false advertising. On the other hand, the more specific the rules are, the easier it is to track down the posts that are not aligned with the rules. And vice versa, the more specific you get, the easier for influencers to comply with the rules. another interesting thing is that ASA basically has a definition of what is considered an influencer, post, or advertising, and those conditions must be cumulatively met. So the first one concerns that the influencer must be paid to create the post, and this is a very broad term. This can be a monetary compensation. It can be some ongoing business relation between the company and the brand, such as influencer being a brand ambassador, or it can basically be receiving a product for free and doing an ad in return. The second condition concerns that the brand or company has to have any sort of influence over the content that the influencer is posting, and this is also very broad, which means it can go from content approval to specific requirements. What do they want from the influencer, or really it's a very broad term. But let's look at some of the sanctions that the ASA can impose that are really interesting. First of all, this is more of a preventive measure than a sanction, but they can give directions to the influencer and guide them on how to comply with the rules. But the interesting one is naming and shaming, which basically when you search a company or an influencer, one of the first things that will pop up on your Google search is going to be an ASA decision or in a form of text on how they didn't comply with the rules, which can bring you a bad reputation, since the ASA actually has an authority in the UK. Also, they may ask to remove paid ads that are non-compliant, and when those sanctions are not sufficient, then Ofcom can impose a financial penalty. Let's look at the case of Serbia. Of course, in our paper, we go more into the depth about the relevant laws, but here let's talk about the advertising law of the Republic of Serbia. In Article 11, it specifies that advertising must not be deceptive or misleading to consumers, and in Article 12, it stipulates that every type of advertising must be clearly identified as such, meaning it must be labeled as advertising content. That's the most specific we get. There's no more guidelines. This is all there is, in contrary to the ASA and FTC that are very, very, very specific. Let's mention also the Code of Business Ethics that's been adopted in 2006 by the Chamber of Commerce of Serbia. It does contain some guidelines on how to on consumer protection and ethical and socially responsible advertising, but it's also very broad, and the oversight of the implementation of advertising laws in electronic media is carried out by the REM, which is a regulatory authority for electronic media, which not only that it has the authority to impose measures, it's also legally mandated to. But in our paper, we talk about how many cases of breaking the law by influencers and company we found, but we couldn't find one simple measure imposed by REM. Now let's, for conclusion, we want to say and get back to the contracts. We strongly feel that we should strive toward the global trend of standardizing influencer agreements, such as its master influencer agreement. Although it is not an official standard, we feel like it proves valuable in preventing potential disputes between the parties, because it really outlines all the key elements crucial for successful collaboration. And when it comes to our legal framework, we can agree that there are basic guidelines and laws, however, they are not precise enough. So we need to enact a detailed regulation. Good example, that's why we talked about ASA and FTC and their standards and requirements. And the conclusion is, as long as there is a lack of specific guidelines, there will be an inefficiency of law enforcement.
Thank you, Nađa and Aleksandar. Now it's time for Jovana for her comment.
Hi, hello everyone. Okay, so let me do this. Yeah, okay. So first of all, my congrats. You did a really nice job, and you should be proud of yourself how you presented your paper here today. I have to say that when I read your paper, my first impression was, okay, there is so many that you wanted to say, but I think that your structure of the paper is different than how you talk here today. And I want to say first, so let me just follow my comments. Okay, the title maybe is a little bit more vague, so maybe you should try to be more concrete. You tackled so many problems and you opened so many questions, which is really, really nice. But I think that you didn't have a line that you wanted to follow, like introduction is like not introduction. I couldn't see what you want to say in the paper, what actually you strive to do during your writing. So maybe when you have like these really good examples, you found this from USA, from the United Kingdom, and that is something you want to like implement in our legal framework as a good or bad example. You will see. It is good to just say how you're gonna do this. For example, we have a problem in the Republic of Serbia in our legal framework. It is this and that. So we decide to look on other examples that may be good for us. So because of that, we're gonna do this. So just to see what is your methodology and why you decided to introduce us with this problem. So I mean, you did it really nice here today when you talk about it, but in your paper, you just need to have like a little bit more, to be just a little bit more concrete. Why is that you're doing? I liked how you explained the children problem and children as influencers and animals. Also, you mentioned that in the paper. Also, I think that maybe this is a part of your paper that maybe you could like dig a little bit more into this. So because it is really interesting and it is really related to the artificial intelligence, that is like a part that maybe you could see what is more to write when you're going to. I think this is like a draft paper, yeah. So you're going to implement the comments, okay. And also, what is my impression? You talk a lot of Republic of Serbia. I mean, you have this headline that is the Republic of Serbia, but there is also a place in your draft paper that you talk about Republic of Serbia as a general rule. So you have to say that this is not like an overall something that is applied on every single time. It's just the Republic of Serbia. For example, you have a law and you are talking about articles on copyright and related rights, but you have to say it like in Republic of Serbia. You had only one headline, Republic of Serbia, and before you talk about USA and United Kingdom. So just try to put, for example, in the USA we have solution like this. In United Kingdom we have solution like this, and then you try to modify these two and see what you can give to as a recommendation for Republic of Serbia. So that, and also introduction. Just try to be try to give us how you're gonna divide your paper, and in your conclusion, just look back what you wrote in the paper. So, for example, when someone does not have enough time to read your paper and he just want to see what you target as a problem, how you're going to deal with this problem, what is your content, and what you conclude at the end. So just a line that you have a start, and then you have it. And be proud of yourself. It's a really nice job here today. Congrats.
Thank you, Jovana. One can tell that you followed my classes on methodology when instructing this. This is really something that, especially since you are at the very beginning of something which might tend to academic career, this is really something that you should follow as a rule, especially at the beginning of the career, to try to summarize things. So abstract or summary, it's and then introduction. They are very similar things. Introduction in the paper is a bit extended summary, but the first thing that you should try to explain yourself what you want to deliver is really to ask yourself, okay, what I will be doing first, what I will be doing second, what I will conclude, what is the main kind of message of my paper. These sort of things should be clear in your mind when you are producing either presentation or the article. So let's start with a round of questions and comments. Yes, please.
Thank you. I have one small suggestion for the authors and concerning what the commentator said. I think it would be good to elaborate more on the concept of influencers in the first part of your paper, in the introduction. So if you're discussing the regulation, you must say who the influencers are. What is that? Why do we as lawyers talk about it at all? So that's just a small thing. Thank you.
Thank you very much, Mila.
I have basically the same question as Isidora. So what is the definition of influencer? Are they the people which main job is providing some content on social media, or they can be some public figures which have Instagram or accounts or some other accounts on social media where they have a lot of followers? For example, because I found that our patriarch Porfiry has Instagram account, so is he an influencer? He has 100,000 followers. He's not following anyone, and he has 500 posts on his Instagram. Yes, but since God doesn't have Instagram, then on Instagram no one.
We do not know that for sure.
So, and should there be any division between influencers and their regulations? So that would be the first question. And the second question is regarding promote gambling on social media. So a lot of our influencers, especially sportsmen, are having contracts with gambling companies. And are such practices violating Serbian law or not? So I found in your paper that you're kind of criticizing that practice, but my question is, what do you think, whether it is in accordance with the law or it is not? Because there are certain provisions that they cannot be. Okay, I will stop here. So what's your opinion on that? Thank you.
Okay, just to see whether there are more comments, Đorđe.
I'll try to provide a couple of brief comments, although I have a lot to say because I did research in this area previously, 5-6 years ago. So in general, I would say that problem statement, I didn't read the paper, I just watched the presentation, but I think there are like many things within the problem statement which can be described. First, like the change of ecosystem of advertising, the price of influencers toward the classical advertising models and compliance of these two regimes, because it seems that like influencers had direct impact on the market, especially it's for child products and so on, against the current limitations in advertising area. And then in the area, you started with the legal form for influencers, but somehow you forgot to say that like most of influencers are performing their work like individuals, and they can enter, they have a legal capacity to enter in a contract, not labor contract, but any kind of contract as individuals, and most of them are performing on that basis. So it's optimal solution for most of them until some point. Then regarding children, it should be taken into account that like children can also be engaged in different contracts. For example, to act in a movie, to act in a commercial, and so on, under the oversight of their parent or person responsible for them. So there is an option in that area, and that should be based on analogy covered. And then I think it's really critical to analyze all the business models available to influencers. And then we have this sponsorship model, brand ambassadors. You just some company just sponsors my content, then there is a lot of product placement activities, and there is a special regulation on product placement, which is very specific. There are affiliate programs, so I present the product, but I also put the link, which is which has some cookie in it, and then if you buy from that link, I get the percentage of the product. So all these, those are different transactions which have different sets of regulations behind them. So could be useful to present them. But the main point for me is, like, when we talk about the regulators, what should be the point of regulation? Do we regulate influencers, or we try to impose stricter regulation on advertisers, or we impose specific regulation on platforms which are the critical for the power of influencers? So these three levels, I think, are very useful for analysis, because my research showed that regulating influencers is really hard, but regulating advertisers working with influencers is much more easier, because the state has much more control over it, and they receive the funds from these corporations. The challenge there is, what if it's a Chinese company advertising Chinese products or US products on this market, and then it's out of reach of our regulator? And the second very interesting question related to the beginning, the legal forms, the transactions and everything are tax issues, because it seems that most of these transactions are not taxed at all. And then that's why I think that, like, strong monitoring and enforcement in field of advertising, collecting all the data about the companies, traders, investing in advertisers, investing in influencers in order to spread message, that's a starting point. And from that point, if the regulator is interested and should be interested, the whole system could be developed. Those are just my ideas in this area. Thank you.
Thank you, Đorđe. Yes, please.
Right. So thank you. So I have a question regarding child influencers, as you mentioned earlier. Is there any way to regulate or stop the child exploitation, especially in the quote-unquote family vloggers, since it's their parents who regulate the content that goes online, but on the other hand, they are making money off of children under the age of 15?
Thank you. I will just have a brief addendum to what was said. Obviously, the topic sparked a large discussion, and I would say that the main problem is really how to define, maybe not necessarily who is influencer. Maybe it would be more easy to discuss what is the activity of influencing. So that's maybe the other way around, to, because the activity of influencing can be a different thing, you know, like sometimes it's about advertising, in other times it's about providing kind of media services. So what is a regular job of a media? In yet another times it's like providing some criticisms of certain content or praise of certain content, like for instance the activity of any art critique. So there are a lot of activities that are potentially could be qualified as influencing activities. So what I want to also emphasize, or to ask you, why you think that the contract or specific, you obviously you see that there would be enough problems of really making an adequate type of contract, but why, generally speaking, you think that a contractual way of regulating things, which is obviously a private law way to regulate things, is superior to public law way of regulating things, which is both American and UK approach to the subject matter. So that's the other angle, whether it should be private law that dictates or public law, whatever is it a kind of regulation or more strict statutory norms and so on and so forth. Okay.
Okay, so thank you all for your questions and the comments. We will try to answer one by one. So first, I want to answer Mila's question. The first thing, the division between the what is an influencer and how do we define the term? Well, basically, the definition given by the dictionary is too broad. It's I will paraphrase. It's a person that has an ability to influence others, but really doesn't say anything. So we can ask a question. So is this public figure an influencer because it's doing paid promotion, or it is not? But I think that the more efficient way to solve this is what ASA did, and they basically defined what an advertisement is in terms of influencer posts with those two cumulatively met conditions. But when we talk about the public figures and are they considered influencers, ASA also gives us the answer to that question, because we found one case where an actress, Vanessa Hudgens, that's how her name is pronounced, was fined by the ASA. So that would partially answer the question. And now I'm really glad that you asked about the gambling. We are all aware that, I mean, we all here have some forms of social media, and we can really see that advertisements on gambling and free spins and other promotions that they offer are everywhere. We think that is against the law. In our paper, we pinpointed some of the articles from law of advertisement and law on games on chance. We are especially concerned when it comes to underage or minors, because there is a certain parasocial relations that forms between an influencer and a young person. So it is harmful for them to see such ads, especially because we are talking here about an addiction. And I would just want you to remember that the legal age for Instagram is 13 years, for example. And I'm not saying that the influencer needs to act as a parent, but there is a certain social responsibility that they have. I hope that answers your question. And now to answer a question about the contracts and private versus public law, I think that the public law solution or approach is better. We see that FTC and ASA are very successful in their regulation. Why I wanted to mention contracts and standardizations of those contracts was because there is a need to also protect an influencer from the potentially economically stronger party, which is a company. So that's why we wanted, just so we can prevent some possible disputes. It doesn't it's not a discussion about whether this should be a private law matter or public law matter. It's more discussion and mixture of both in order to enhance the regulation of influencer. And that's what I have to say.
I want to answer about using children. Maybe we can involve social services in preventively talking to kids about how they feel, or are they forced to do some sort of work, and maybe that can help in using and exploiting children in that case. And that's what I have to say.
Okay, thank you very much. Just to read the message from my dear colleague, Professor Tatiana, who transmitted her gratitude for our inclusion of her students from the economic law study group into this conference program. The pleasure is ours. We were cooperated very successfully, and all of you will have the opportunity to see the fruits of this cooperation. Now it's time for the small break. Since we are a little bit late, we will shorten it in 5 minutes, shorter than initially envisaged. So 12:15 we proceed with another session. Thank you.
Just checking, Lady Nieto, can you hear us from here, from the conference?
Yes.
And can we test whether we can hear you? So please just test the speakers.
I can hear you now. Thank you.
Good. Thank you for your taste and your confirmation.
Can you please repeat what you said? We couldn't hear you. Can you hear
I
us?
was trying.
Could you hear?
Could you hear us?
I was
Could you
trying
hear
to
me?
be sure you are hearing me because I have an.
Okay, we can hear you now. If you can hear us, just speak a little bit louder when we start with this session.
Yeah, I can hear you well, so I
Thank
just wanted to
you.
be sure you can hear me. Okay, thank you.
Ovaj problem sa zvukom.
Pa nije čula Dobro.
Sad ćemo da krećemo. Sada ćemo da krećemo.
Vidi ovo mi je kako da ostaje. Pogledaj.
Evo ga.
Recording, samo vidi radim. Da. Evo ide on tu danas. Dobro.
Okay. Sad ćemo da ih pozovemo. Dobro, Sofija Lekić je nam tu. Sofija dođi, a komentatorka nam je online.
Sofija, samo da proverim vaša prezentacija. Da. Sofija Lekić. Jedan. Čekaj, ovo. Dobro, je to prezentacija.
Dobro.
Sad ne treba da pojavim da i oni vide. To recimo uopće nismo radili.
Okay, the online participants, can you hear us? Can someone say whether you hear us or write in the chat box?
I can hear you well.
Okay, can you see the presentation?
Yes, I can.
Okay, great. Sačekamo onda.
Jel to bila ova Leydi? Je to ona pričala? Jer čuli smo odlično.
Can I ask you how to pronounce your name? Sofia?
Sofia.
Sofia, okay.
Yes.
Like in Spanish, okay, good.
Super.
Možemo da počinemo.
All right. Hello, everyone. My topic for today is the impact of digital technologies on the cultural rights of deaf and hard of hearing people. So in order to address this topic, I divided my paper and my presentation today into 3 different sections. The first section deals with the concept of cultural rights and the general concept of culture as the one tied to this. The second section is concerned with defining the labels of deaf with a lowercase letter, deaf with a capital letter D, and hard of hearing people. And the third section concerns digital technologies and their impact on the topic at hand. So the first topic I'm addressing is the topic of cultural rights. These rights belong to the second generation of human rights alongside with economic and social rights. However, in comparison to these two, cultural rights are often overlooked and underdeveloped,
So often much less attention is given to them in schoolwork, in academic research, etc. So it stands to reason that the first step in my analysis is defining which rights are part of this group at all. In order to do this, I consulted both legislative acts, mostly international legislation, and academic works, and came to a separation of these rights into two categories. Those guaranteed by the International Covenant on Economic, Social, and Cultural Rights, and those which are not mentioned in this legal act. This is, of course, not an official classification, but I believe it to be useful to understanding the general concept of cultural rights and the meaning I use them in this work. So when talking about the rights guaranteed by the Covenant, the first one and the most developed one generally is the right to education. However, aside from this one, the Covenant also mentioned the right to take part in cultural life, as well as the right to enjoy the benefits of scientific progress and its applications. On the other hand, there are other cultural rights not mentioned in the Covenant. However, they are nonetheless valid or important, but just less universally recognized in legislative acts. The first one I would like to mention here is the right to culture. And at the first glance, this one seems quite similar to the right to take part in cultural life. However, there is a certain distinction between the two, stemming from the different understanding of the concept of culture and cultural rights. The first point I'm making here is that if we regard cultural rights as individual rights, the right to take part in cultural life is what we're talking about. However, if we talk about cultural rights as collective, as pertaining to a certain group, specific group of people, then the right to culture is the more appropriate term because it deals with culture not as a universal entity common for all humanity, but rather as pertaining to a specific group of people. The next aspect of the right to culture I'm addressing is the protection of cultural heritage, both tangible and intangible. I go into more detail about this in the paper. However, for the sake of staying within the time frame today, I will just move forward from this. And the next one could be considered an aspect of the right to culture, but also a separate right in its own right. And that is the language rights or the linguistic rights, which are defined as the right to identify with and access education and public services in one's mother tongue. So, as we have already seen, all these rights are types of culture, and also in my paper this is more profoundly addressed, but here on the slide, yes, here on the slide you see some of the definitions I encountered in my research of culture being defined as a product of man through history, as the overall capital of created cultural works, as the creativity involved in the production process of cultural works, as a way of life, high culture, popular culture, sets of collective memories, and many other definitions not involved here. However, for the purposes of this paper, the most appropriate definition is culture as a way of life. Moving on, the second section of the paper concerns defining deaf with a lowercase letter, deaf with a capital D, and hard of hearing people. And the difference here stems from two approaches or two models being applied. The first being the medical or social model, and the second being the cultural linguistic model. The medical or the social model recognizes two labels. One is deaf with a lowercase letter, and the other is hard of hearing. It is a concept rooted in audiology, and it just measures the level of absence of the faculty of hearing in a person. That is the level of hearing loss. In that regards, mild to severe hearing loss is labeled as hard of hearing, while profound hearing loss signifies a deaf person. On the other hand, the cultural linguistic model concerns the capital D, deaf people, and it is not concerned with hearing loss, but rather its antipod, the deaf gain, which is a construct given by the deaf community, and it focuses on the cultural experience, on growing up with severe deafness as the reality of childhood, of using sign language as one's mother tongue, of a linguistic community full of cultural solutions of its own. And one opinion often encountered in deaf studies with a capital D is the opinion that those people are not disabled, but different. So now I move on to the main topic of this, and the one which made it possible for me to present at this conference, whose topic is digital technologies. and that is the digital technologies which impact the cultural rights of deaf and hard of hearing people. Here on the slide, I pointed out some of the technologies which have the greatest impact, and I won't go into too much detail. We can talk about each of them for much time. However, all of them have certain benefits and drawbacks. In some regards, they offer a way for deaf people to access cultural works or educational content in a more accessible way, such as hearing aids or subtitles for movies, TV shows, whatever, automatic speech recognition software, which helps them get a transcript of what is said in their surroundings, etc. However, there are also certain drawbacks to these technologies, such as the fact that oftentimes hearing aids are seen by the members of the deaf with a capital D cultural community as a negation of the right to be culturally deaf. Also, subtitling, as good as it is often, can be difficult because for the deaf, culturally deaf, the sign language is their primary language. So any transcription is in their second language, making it difficult to comprehend. And also subtitling is such that the subtitle is either overcrowded by the author or subtitler attempting to include everything conveyed by the vocal message in it, or just not getting the full message across because you see the text but not the speech speed, the intonation, or whatever else. So I would get to the conclusion here. I'm open for questions later, of course. Digital technologies are ambivalent when it comes to cultural rights of the deaf community. They can be a huge asset in making certain content accessible to these people, which otherwise wouldn't be. However, there is a certain risk of the hearing community being biased and seeing these technologies as the total cure and saying, well, okay, they have these technologies, there is no need for us to do anything else. Well, this is not the case. These technologies are not as reliable or as successful as we may think they are. And in this regard, we sometimes discriminate deaf people just by thinking this is not for them when it is not. And also, one danger of the technologies being as effective as they claim to be is the evocation of the opinion that, for example, sign language may become unnecessary in the future, because after all, if we can make hearing content available for the deaf equally, then at a first glance, there is no reason for sign language to be present. However, this would be a violation of the linguistic rights of this community, and also a reiteration of an earlier historical occurrence where sign language was suppressed. So when taking into account cultural rights, this is a double-edged sword. So in the end, the responsibility lies not with the developers of the technologies, but rather with those who determine how these technologies are used. And we must all keep an open mind to the different perspectives in order to make the most of what they have. Thank you for your attention.
Thank you, Sofia. Just to mention afterwards, because Sofia started to do her presentation, that she is an undergraduate student here at the Faculty of Law of the University of Belgrade and at the Faculty of Political Sciences. So this was really a comprehensive presentation about really an interesting topic. So as a commentator on this topic, we have a Leydi Nieto from the Universidad de la Sabana. Can you hear us? Did you hear everything we checked? Thank you. So she's online with us. So you have 5 minutes for the comments. Thank you.
Thank you. Hi, everybody. Thank you for inviting me to this event. It's an honor to be here today. Sofia, I would like to thank you for this wonderful presentation and interesting article you wrote. I wanted to begin by saying that the topic we are discussing is so important and exciting. You have pointed out a type of right that it's not studied in details, as you said, especially the right of a specific group of people. Thank you for your research and taking the time to delve into this topic. We need more research, in my opinion, like this. I really enjoyed reading your article and learn about the cultural rights of deaf people. Currently, I'm researching about people with intellectual disabilities and how artificial intelligence can be used as a tool to exercise legal capacity. I see some relation between our research, especially regarding the discussion about the diversity and the models used to treat specific groups. I have some comments that I would like to share with you. I hope that it can help you to improve your final version of your article. The first one is the relation between introduction and conclusion. There is a need, in my opinion, to develop the conclusion further. The introduction was broader than the conclusions, especially when you said that you will provide guidance for the period ahead. So check this relation between what you said in your introduction and the conclusion, and make sure you are, you accomplish what you offer in your introduction. To make your article more powerful and attract readers, I suggest including some statements that explain why you are researching this topic. What is the importance to the current state of the play? You can use your great job to grab the reader's attention from the beginning. In the section of cultural rights and concept of culture, just think about it. And I don't know if it could be more logical to start this section by analyzing the concept of the culture before defining cultural rights. Because just said in that section that the definition of cultural right is founded on the concept of culture. So think about it. Finally, you can delve deeper into the subset of the cultural concept because it's in my opinion was a little general, so you can explain more. In the section between difference between deaf with capital letter and hard of hearing, it was so interesting to learn about the difference between these labels, but it was a little difficult to understand at first. I suggest making it clearer what exactly each labels means. It could be done in the introductory paragraph of this section. In the section of digital technologies affecting the cultural rights of these people, I think you can check the use of verb affect. And in this section, the title implies a negative perspective on the impact of digital technologies. However, you have recognized in your article both positive and negative impacts. So check this, the use of this verb in this section, and others you use this verb, use affect as a verb for refers about impacts. As this section is the core of your research, it is important to explain more your position and provide the corresponding arguments to support your stance. And finally, in this section, you can elaborate further on technology you chose as examples to help readers to understand these technical topics. Finally, to condense the main ideas of each section, you can provide a summary at the end of that. So you can consider creating a short glossary to explain technical terms. Additionally, it might be worth exploring the concept of inclusion for your topic, which you can highlight deaf people as a part of diversity and how these tools can be part of this purpose. And lastly, check your bibliography because I think some of your resources are not recent, and specifically when we are researching about technology, they change rapidly. So check this. I'm going to send you some suggestions, specifically some reports for some international institutes about it that I think can help you to check this. That's it. Thank you for your important work and keep researching to give voice to those who don't have it. And I'm looking forward to reading your final version of this incredible article. Thank you so much.
Okay, thank you to our commentator for these very detailed comments, which I'm certain will help Sofia further improve her paper. And now we open the floor for the discussion. We have approximately 10 minutes. So do we have some questions or comments from the audience, online and here in person? Oh, Jules, yeah.
Thank you very much for your presentation. I am so sorry that I had to leave in this very stupid way. So sorry for interrupt. I was wondering if you could maybe say something else about the importance of the cultural rights as a category, in the sense of, because I was wondering whether this is important, for example, to ascribe some special consequences or ascribe some special need to protect. But I think that is somewhat related to the last part of your presentation when you talked about technology and responsibility in the use of technology. But in this sense, I was wondering whether there are other categories of second generation human rights, if we can talk about these, that could be assimilated or similar to cultural rights in this sense in particular. Thank you.
Mila, did you want to add maybe a question?
Yes, first, thank you, Sofia, for this really clear presentation. I have one question regarding the usage of these technologies in Serbia. So are they used in our schools? And if they are used, are there any problems with accessibility of these technologies to people who are using them? Are they costly? And are they affordable? And since I guess the answer is no, are there any legal solutions? Who should be the provider of these technologies? Thank you.
Okay, once more, are there some other questions or comments from the audience? Okay, if not, I would just relate to what, sorry, Anna.
I will follow up to Mila's question regarding technologies. I think that the better point is to maybe research whether the state is providing a means for those kind of support and technologies. And I think that in our law regarding the school books or something like that, there is a legal ground for such a support. Thank you.
Okay, thank you, Anna. And I would just follow up on what Mila and Anna have asked, so maybe you can take it all like together and answer, of course, in Joel's questions as well. But when we speak about the second generation, if we talk so about human rights and speak about economic, social, and cultural rights, I'm interested in your opinion, like when we discuss economic rights, for example, the minimum wage, whether you think that such a concept, like the minimum level of economic rights, should also take into account the cultural rights and the need of each person to have some rights in this sphere. I'm not, if there are some questions regarding what I have posed, but that's, sorry, that's my question, so thank you.
Well, first of all, thank you everyone for very interesting questions and very valuable comments. I'm sure they will help me a lot in making the final version of this paper presentable. I would first review what my commentator, Lady Nieto, said. So, yes, I did see some incongruence between my introduction and conclusion. Let's just say it was an ambitious start to a very rushed finish of this draft version. So, it is my hope that for the final version, I will fulfill everything I promised in the introduction. But for now, yes, there is much need for the conclusion and for the main part of the paper to be more fleshed out. This is just, shall we say, a list of ideas which I plan on developing further. And thank you for the idea of including my motivation for researching this in the paper. It is, I must say, something I do not very often see in our papers here, because it's just often seen, well, we are researching this because we are interested in it. But yes, it would be nice to mention something more about that. So I will make sure to include that. And thank you for the advice on restructuring the part on culture and cultural rights. It was a big question for me because the whole topic is kind of difficult to put into a linear structure. It is more of a three-dimensional work. So yes, maybe it would make more sense to address the concept of culture in general before cultural rights. And to make many parts clearer, as I said, this was more of a list of my starting points. And yes, there's much more work to be done in order to make this right. So, and bibliography, yes, technology, it was a little bit rushed. I had many ideas, but couldn't really find the resources I needed. So thank you very much for offering to send me some, and it would be very helpful so I know at least where to start. with fixing this, because yes, the literature on digital technologies from 10 years ago is not really the most relevant source, and that's something that needs to be fixed. So thank you very much. It was very helpful to hear what you had to say on this, especially taking into account your experience. As you said, your research area is not the same as mine, but it's very nearby. So it was very nice to hear what you thought of this. Now I'll answer the questions from the audience. First, from Professor Rabanos, the importance of cultural rights. Well, here I risk running into the slippery slope of saying, yes, culture should always be protected. Yes, it is a universal value, etc., which is true, maybe, but not really the strongest argument one can give. However, we must see that culture is always an influence on every legislation, whether it is visible or not. So the legislation made about deaf people is usually made by hearing people, because they are the majority, they are the ones who can talk in parliament among themselves in vocal languages, and thus have much more influence on legislation. So it's not just a question of protecting their cultural rights for the sake of protecting their culture, but also for the sake of giving them a voice, because they are the only ones who really know their situation and their needs. So in this regard, it is necessary to let them speak, because of course their community is not homogeneous, just as the hearing community isn't, but they are capable of giving us a perspective which we may not be able to see. There is a historical example of this. I mentioned this in the conclusion, of suppressing sign language, because a group of hearing people decided that oralism, that is teaching deaf children to speak, to read from lips, etc., would be more effective. However, a few decades down the line, it was proved to be anything but. And had we listened to the deaf community back then, many generations would have had a much better opportunity for education, for being integrated in society. Instead, they are left without many knowledge they could have gained. So that would be my main point, why cultural rights should be protected. And also, if we leave it to not protecting cultural rights, we run the risk of being not colonizers, but somehow making everything fit into the mold of the Western abled most majority homogeneous society, and it runs the risk of making us all the same, and diversity is important. The next question, Mila, about the usage in technologies in Serbia. I must admit, I didn't really focus much in Serbia here. This was more a theoretical paper, but from my knowledge, just from everyday life, no, this is not accessible. This is not even known to many people that it exists. I mean, we can just check on the internet and see where the world has developed, but mostly in our education, the attempts at inclusion of people with disabilities or different abilities or whatever is just not developed enough. We have special schools for some, we have integration in the mainstream schools in other cases, but there is much to be improved here. And well, who should be responsible for this? Well, me personally, I would say the state, but our legal framework right now is not firm enough to support this, because there is much said about medical accessibility devices, etc., but those are more focused on physical disabilities, on situations where it is practically impossible to do anything without these devices. However, the question we are dealing here with is not the impossibility, but the impracticability and the lack of accessibility. So there is much leeway for the state to say, well, this is not absolutely necessary. It's just an improvement. So yes, this is something we should develop upon in the future, but right now I don't see much of a legal leg to stand on, unfortunately. And the correlation between providing books and providing this support, well, yes, theoretically it sounds great, but unfortunately we see that even with books, it's just sometimes for the third or fourth child and family, or for just the capital city or whatever. So even there we haven't achieved the best system. Maybe the best system is not to provide everything for everyone, but to those vulnerable categories, we should provide what they need. And I unfortunately don't see this happening in the near future as much as it would be good to happen. And the connection to the economic rights, well, I must say I didn't really understand right what you meant about this. Should we take into account the cultural rights of people into the economic rights? Well, it is all connected. because, as I mentioned, the most developed cultural right of them all is the right to education, and it is kind of a prerequisite for economic rights, because, as we see, without education, there is no way for people to make minimum wage, because more and more jobs are not even for elementary education, but we also see the raising of standards, etc. But could you clarify, please, this connection?
Yeah, we're running out of time, so just maybe to think about. But what, of course, the point you made regarding education and employment, which are closely, of course, related, is important. But just like something that is very like open to discussion is whether when state determines, for example, minimum wage for that year, whether minimum wage should cover only roof over your head, food, and some basic needs, or it should also encompass some basic cultural rights.
Yes, now I understand what you meant. Well, ideally, it would encompass other cultural rights, but this is tricky not only in that the economic state of the world is such that setting such a standard for minimum wage would be a little bit impractical, maybe, but also because it is difficult to measure how much economic resources a person would need for fulfilling their cultural rights, because culture is going to cultural institutions, but it is also interacting with people of the same cultural group. So some of these options are more costly, some are practically free. And well, it's a nice idea, but right now on the spot, I have no idea how it will be implemented.
That's just something to think about. Thank you. If there are no other comments or questions, I would like to thank once more to Sofia Lekić for a great presentation and to Leydi Nieto for her comment. Okay, so with that being said, we're moving on to the second part of this session, and I would invite Marija Vranić, here from the Faculty of Law of the University of Belgrade, and Jovana, also from the Faculty of Law, to join us here. Okay, as Mila helps me open the presentation, just to say that the topic of Maria's paper is a legal potential of digital assets in the light of companies' business operations. So, as we know, 15 minutes for the presentation and 5 minutes for the commentator. So, the floor is yours.
So, distinguished professors, fellow participants, and guests, I would first like to say that it is really assets is necessary. So since we are limited by the time we have at our disposal, I will try to be as quick as possible and to explain only the outlines about digital assets that will be sufficient for further and main considerations. So law on digital assets recognizes two types of digital assets. I will first talk about virtual currencies. Virtual currencies are not issued or guaranteed by a central bank or a public authority. They do not have the legal status of money or a currency, even though the name might suggest otherwise. But what is important to understand that virtual currencies actually can be exchanged for money, and they can be exchanged on some other types of digital assets based on their exchange rates. They do not exist in physical form. Other type of digital assets are virtual tokens. And virtual tokens represent only an intangible property that represents in digital form one or more property rights. That is the essence of the definition. There are many types of digital tokens, but I will focus mostly on security tokens since they are important for further analysis. So security tokens may grant access to the ownership of a company, or maybe a dividend distribution, or even some voting power. Overall said, they are granting access to financial benefits of the token's issuer company. What is important to consider is whether is the legal position of digital token user the same as a legal position of a holder of a security, for example, stocks or bonds. There is a situation where law on digital assets stipulates that some digital tokens can, in digital assets in general, may have the futures of financial instruments. And that really is the case when I analyzed it, but I wouldn't say that just because some digital assets has the futures of financial instruments, it is enough to equate them with financial instruments. They have their own legal nature. So to the main part of my research, I was dealing with can be a contribution to a company and in which form. To address this question, we must consider what is said both in law on digital assets and that there are two types of contribution to a company, that is in-kind and pecuniary contributions. So these in-kind contributions may be in intangibles or tangibles. So is there a place for digital tokens to be a contribution, since I said that digital tokens are intangible property? The answer is yes, but there is a condition. A digital token may be a contribution to a company as long as it is not provided to relating work or execution of work or providing services. But even that type of digital token can be a contribution to a company if we are talking about a contribution of a partner or a general partner, because that is a corresponding exception in the Companies Act. It is different with virtual currencies. Virtual currencies, as I said, are not money, so they cannot be exactly considered to be a pecuniary contribution to the company. But what can be done in this case is that virtual currencies can be exchanged for money, for example, for a certain amount of dinners, and then they can be paid to a contribution to a company as a contribution. But to conclude this topic on virtual currencies, they cannot be in their original form entered, actually paid, to be more precise, as a contribution to the company. Another important question is how to appraise the value of digital assets. It is not that hard when we are talking about virtual currencies because they are exchanging on their exchange rate. But when it comes to digital tokens, there is no direct answer, neither in law on digital assets, neither in Companies Act. But what Companies Act does stipulate is that in-kind contributions are appraised by certified witness expert, auditor, or another person that has an adequate qualifications to address this issue. So is this provision from Companies Act applicable in the case of digital tokens? I would say that there are no obstacles for this provision to be applicable in this case. What is important to understand that the subject of appraisal is not a digital token itself. Digital token is just a digital record that is functioning on a blockchain technology or another digital ledger technology. The very essence of digital token is the one or more property rights that is incorporated in them. So I would say that the nature of that right is what should determine the direction of the appraisal of a digital token. An interesting problem is how to appraise the digital asset that have the futures of both virtual currencies and digital tokens. That means that they can be at the same time used as a means of exchange, and they have a certain rights incorporated in them. There is, once again, no direct answer, so we must rely on provisions that are already existing. So I would say that in that case, if we use that digital assets as a means of exchange, that means that we now have a certain amount of money for which we exchange it. Money will be paid as a contribution to the company. If we didn't use it as a means of exchange, that means we have a digital asset that has a certain rights incorporated in them. And once again, the nature of that right should determine our direction of our appraisal. And that potential of a digital assets to be maybe in the future exchanged for money or for some other digital asset just has to be kept in mind. But we cannot. Another matter that I dealt with is what is the relation between digital assets and dividends? To be more precise, is there a possibility for dividends to be paid to stockholders in form of digital assets, virtual currencies or digital tokens? Important. We must first look what Companies Act says on this matter. Companies Act says that dividends can be paid to stockholders only in two forms, in cash or in stocks. So these possibilities are limited to these two ways. When it comes to virtual currencies, I already said that so they cannot be in this sense used as a cash, as a money to be paid as a dividends, and of a stockholder for dividends to be paid to him in form of virtual currencies. And when it comes to paying dividends in stocks, we must always keep in mind two important conditions that are provided in the Companies Act. And that is that such payment shall be approved by the stockholders of the class of stocks to which such payment is made under the rules on voting of stockholders within a class of stocks. And the payment to each stockholder of a class of stocks who is entitled to dividend is made in stocks of that class. There are certain exceptions, but never mind them. In this case, they are not important. So I wouldn't say that it is enough clear how can we apply these rules on digital tokens. Maybe in some ideally imagined situation where instead of stockholders, we have digital tokens users that can types of classes according to the rights that are incorporated in the digital tokens they are users of. But since that is not the case, I wouldn't say that in reality dividends can be paid neither in form of virtual currencies and in digital tokens. And for the last part of this presentation, I will just talk about some interesting formalities that must be met in order for companies to provide digital asset services. Digital asset services are numerous, maybe not numerous, but there is a lot of them. I wouldn't waste my time just repeating what law on digital assets says. I would say that these digital asset services may be also of an advisory nature. And that is important to distinguish because if a digital asset service is of an advisory nature, then not only companies, but entrepreneurs as well can provide those types of services, which is justifiable given the fact that they are accompanied by with less risks and formalities. But if we're talking about ordinary, let's say ordinary digital asset services, they can be only provided by the companies. That means partnership, limited partnership, joint stock companies, and limited liability company. I also tried to summarize the questions about minimum share capital. That was really interesting topic for me. I will be honest, when I first tried to research this topic, I expected the minimum share capital for digital asset service provider to be a lot higher than it actually is. So I will first like to make some introduction on this matter. So when it comes to limited liability companies, the minimum share capital as it is stipulated in Companies Act is only 100 dinars. There is a logic behind that. I will not talk about it right now. And when it comes to joint stock companies, it is a lot higher. It is 3 million dinars, which is, if I calculated correctly, about 25,000 euros. So we can see, and when it comes to digital asset service provider, for majority of services, the minimum capital is only required to be 20,000 euros. There are certain exceptions, but that is when the digital asset is accompanied by really great risks, and then that is justifiable. So in this sense, let's say a regular joint company that does not provide digital asset services is required to have a minimum share capital that is higher than a company that intends to provide digital asset services. I expected minimum share capital to be higher because I considered the digital asset services to be really complex, which is no doubt that they are. But what is the logic behind this? I would say that this is a consequence of a legislator's will to loosen up conditions that are required, because if the minimum share capital is disproportionately high as a requirement, that could lead to undesirable consequence that companies that are potential future applicants actually at the very beginning would not consider to even provide any digital asset services. As far as I know, only 2 companies in Republic of Serbia for now are providing digital asset services, and that digital asset services is not their main activity, so they are doing something else beside that. And for the last part, I would say that a license application process for a company that will be a future provider of digital asset services is very complex. The list of data that companies that are intended to provide these services is very extensive. So there are a number of conditions that they must meet in order to provide these services. And my observation on this matter is that the legislator really devoted a special attention on some conditions that are related to long-term planning activities when it comes to three pillars of this area, that is personnel. So we must have people who understand what they're doing, let's say it like this. Of course, there are some things that must companies consider when it comes to security technology when they are providing digital asset services. And everything that is required by law on digital assets, I would say that the main reason for these strict conditions is for companies to really assure the supervisory authority, that is security commissions in Republic of Serbia, that their intended business is indeed enough stable. And because of that stability, they want to ensure that the Securities Commission will make a positive decision on its requests. Of course, this is really complex topic. I put an end, I think, maybe even before I really wanted to, when it comes to some questions, for example, what is the relation between the obligations that companies have when it comes to preventing financing terrorism and money laundering in relation with digital assets services and digital assets in general. But I think that would really broaden this research. So maybe in the final version, I will include that research as well. But this is it for now. Now it's time for comments, for questions, and for discussions.
Thank you, Maria, for this really great presentation on, as you have said it yourself, but very complex issue. So even for us that maybe weren't so familiar with this topic, you made great points which we could all understand. So thank you for that. So we give the floor now to Jovana for the 5-minute comment.
Hello, everybody. My name is Jovana and I'm a 4-year student here at University of Belgrade, Faculty of Law. And today I'll be commenting on Maria's paper. I will try to examine the academic potential of this paper, and furthermore, I will provide some criticism for specific parts of the paper for which I do believe that there is a room for improvement. At the very beginning, I would like to say that author chose a topic that is quite original, current, and still under-researched, which is confirmed by the fact, by the conclusions that she reaches in her paper and also the ones that she does not. Such authorical behavior for sure deserves prize. And also I think that the topic that you choose fully corresponds to the theme of this conference and the magazine that it has the potential to be published in. And also regarding the fact that you deal with the basic issues and concepts from company law and digital property law, I think it's not wrong to say that this paper even has the potential to be a part of some kind of reviews dedicated to commercial law. In the introductory part of the paper, author tells us that her main guiding sources of law while writing are Companies Act and law on digital assets. It seems to me that particularly at this point of the paper, introductory part, it is important to pay additional attention to the decisions written by International Monetary Fund and National Bank of Serbia, which you often consult throughout writing. The specificity of these sources, I think, would they for sure enrich the paper. And that's why I think that this institutional normative framework deserves maybe wider context than it has precisely in the introductory part. Then the author explains the concept of digital assets, its types, and while doing that, you are concentrated on domestic regulation. You are referring to relevant articles of law, legal theory. Maybe there is a room for progress in terms of not opening in depth the question of classification of digital assets, which represent a quite open debate in legal theory. By mentioning the classification, I do believe that the framework of the paper set in this way would not be exceeded, and completeness would be achieved, and readers could maybe easier follow and understand the need for the examples that you are mentioning, such as security and utility tokens, and maybe useful literature in that way could be guidelines for inquiries regarding the regulatory framework for initial coin offerings written by Swiss Financial Market Supervisory Authority. I'll send it to you later. Then I'm coming to the approach in examining the key questions that answer the basic question of the potential of digital assets in the company's business. And I would particularly highlight them as positive. The explanations are very fluent, they are very understandable, matter is presented in a logical manner, and valid conclusions are drawn. But it seems to me that more criticism could have been directed at the existing solution that deals with the issue of distinguishing financial instruments on the one side and digital assets on the other, which is in our law set quite broadly, and the application of vision become only clear when only by examining in more detail. Regarding the presentation of the topic, I would maybe recommend that your thinking should go in a way of presenting the issue of minimal capital before other sections like right to dividend services in company, just like traditional textbooks of company law do. Call me old-fashioned, but I really do that. That would preserve the chronology that comes from the fact that minimal capital is core and heart of companies' business operations in terms of Companies Act. At the very end, I would like to touch upon the concluding part of the paper, for which I think it's quite inspiring because you practically opened a new direction for research that will deal with issue of regulating the procedure of a kind of conversion of virtual currencies into monetary contributions. I will conclude my comment now by expressing my honest gratitude to you, Maria, for choosing this moving topic that really inspired me today to participate. It was my first time, hopefully not the last one. So thank you. Thank you.
Thank you, Jovana, very much for this detailed comment, which also I'm sure will help Maria to further work on her draft version of the paper. Okay, so do we have some questions or comments from the audience? Okay, first time. Okay, yeah, maybe I have a question. You touched upon this issue, and you have far more expertise in dealing with that issue. So maybe this question is kind of like something already mentioned, but I'm interested in this aspect of development in digital currencies and generally that our national legislation and in general law for now fails to recognize. Do you perhaps see some perspective, like to say in the next 5 or 10 years, are you optimistic that the law shall recognize it, or it is something more in the future that we should discuss and have in mind for now? Thank you.
We may be, Republic of Serbia may be even hurried up when it comes to the law on digital assets. I have been reading some articles on the law itself, not on this topic. When Professor Mirjana Radović, for example, she said that some things are more in accordance with the European Union perspective, not from ours, and that, for example, definitions of digital assets, virtual currencies are too wide, they can be narrowed down, that there are still things that are not exactly the way they should be. When we are talking about our legal system as a whole, I would say definitely the digital assets have a great potential for future. There is a plan to make the law itself better. Of course, the practice will show how should we deal with this theoretical question. because even this law was passed, I think 2 or maybe 3 years ago. This topic is not that young. As the first professor said, we are dealing with digital technologies far more than that. So I would say that we should leave things to practice to see how everything will go, and then to change maybe some things that we perceive as not so well when it comes to theory.
Okay, thank you.
And yes, I remember to say thank you, Jovana, really for these fruitful and inspiring comments. I agree with you. I'll be honest, I had some troubles when it comes to literature of domestic authors. I couldn't find enough articles, especially related to this topic I have been dealing with. Only some general issues, for example, what are virtual currencies, what are digital tokens. So for a majority of conclusions that I was writing about, I couldn't find appropriate foothold in domestic literature. So I could only rely either on law on digital assets, either on Companies Act, and to combine that. So even myself, I'm not sure if it's that, if it is really how it should be. But everything I was writing about is just some potential, let's say, potential solutions, and we will see how the things will go in practice. Thank you.
Thank you once more. If there are no questions from the audience here or the online participants, that someone maybe have a question or a comment. Okay. If not, I would like to once more thank Maria and Jovana for this very interesting. Okay. Thank you. And we move on to the final part of this session right before lunch. So in that regard, our speakers are Liliya Kazak from the Belarus State Economic University Faculty of Law, who will present the paper on the topic Influence of Blockchain Technologies on Civil Law Relations. And the commentator is Cecilia Isola from the University of Genoa. Our participants should be online, so please let us know whether you hear us, and yes, are the author and the commentator here?
Yeah, I'm here. Can you hear me?
Yes. Okay.
Perfect.
Okay, that's Cecilia. And what about Liliya?
Yes, I'm here. Can you hear me?
Oh, okay, now we have all the necessary prerequisites to start with this part of the session. So, Liliya, the floor is yours. You have 15 minutes for the presentation of the paper.
Organizers and dear participants, I'd like to take part in your event, and want to tell that my internet connection is a little bit unstable, so tell me please if something will be wrong, okay?
We can't hear you now. Could you repeat that to see if we can hear you? Liliya,
can you hear me?
Now we can. Okay, thank you.
Okay, good. So please tell me if something will be wrong. I will repeat my my words. So I want to tell you some words about influence of blockchain technology on civil law relations. Currently, the whole world is striving for development, which is manifested in the introduction of the latest achievements of mankind into all spheres of society. This process is called digitalization or digital transformation. Digitalization, in a broad sense, is the process of modernizing one or another area of human life through the introduction of digital technologies. So, digitalization began back in the 1940s. In the science, as computer technology improves and becomes cheaper, the digitalization process has expanded and penetrated into more and more spheres of life. The invention of a microprocessor in 1971, which could reproduce in one chip the functions of the processor of a large electronic computer of the time, was decisive in the development of digitalization. Thanks to this, in the 1970s, there was a qualitative leap in technology, and the world received such a benefit as personal computers. The first of these was a research prototype of the Xerox Alta, which featured a graphical interface and a desktop metaphor. Speaking about its improvement, the next important stage in the development of digitalization was the emergence and rapid development of the internet in the late 1980s till 1990s. The principles by which the internet is built were first applied in the ARPANET network, created in 1969 by order of the American agency DARPA. Based on this work, in 1984, the United States National Science Foundation created the NSF-NET network for communication between universities and computing centers. The ARPANET was a closed network, while the NSF-NET was freely connected and by 1992 had more than 7,500 small networks connected to it. So with the transfer of the NSF-NET core network to commercial use, the modern internet appeared, in which the concept of a data transmission network between physical objects, meaning things, equipped with built-in tools and technologies for interacting with each other or with the international or with the external environment was formed. The Internet of Things. Later, with the expansion of devices, the population using with the population of the Earth, the Internet of People became the Internet of Things. And during the period from 2008 to 2009, there was a proliferation of smartphones and improvement in their functionality, as well as the emergence of new technologies, software development and production automation. Today, digitalization has covered almost all areas of human life: economics and finance, public administration, culture, education, healthcare, ecology, and of course, law. The development and use of technology such as blockchain deserves special attention, the emergence of which caused a great resonance in society and became another qualitative leap in development. So the concept of blockchain means register of transaction blocks, is enshrined in Clause 8 of Appendix 1 to the decree of the President of the Republic of Belarus. Number 8. This is a sequence of blocks with information built on the basis of a specified algorithms in a distributed, decentralized information system that uses cryptographic methods of information protection about operations performed in such a system. In other words, it is an information database that reflects all completed transactions. Currently, blockchain is used in various fields. For instance, in cryptocurrency, it was the blockchain that forms the basis of cryptocurrency, thanks to which Bitcoin, Ethereum, Litecoin, etc. appeared. Then another area is banking, investment, and exchange activities. Blockchain is going to be used by such payment systems as Visa, MasterCard, UnionPay, and SWIFT. This technology is also used by banks to carry out various operations, for instance, money transfers. Another area is land registry. Sweden, Ukraine, and UAE plan to maintain land registers using blockchain technology. Then, identification. Microsoft, the Brazilian government, Finland, and Estonia are already using blockchain for these purposes. Means of payment. The World Food Programme is using blockchain to provide food to refugees through special retail outlets and networks, instead of directly distributing food to refugees and giving them cash to buy food. Another sphere is gaming industry. Moreover, we can use blockchain in government. Blockchain can be used to conduct transparent and trustworthy online voting and elections. Another sphere is data storage. Blockchain allows you to store data in decentralized manner, which facilitates its reliable preservation. Another field is notarial sphere. Using blockchain will allow you to create immutable records and track all notarial documents. It will verify their authenticity, ensure the security of transactions, and reduce the cost of notarization process. And of course, guarantee confidentiality. Another is copyright. Blockchain will help people in creative professions retain the right of authorship to their works. With the help of digital identification and certification, creative products will be created, the rights to which can be transferred from the author directly to the buyer. At the same time, intellectual property will be protected from the legal side without the usual intermediaries in this area. Finally, nowadays, it's very difficult to track the movement of goods, since they are supplied by different companies from different places. Blockchain will save manufacturers and consumers from counterfeits and facilitate the certification of traceable products. Speaking about the principle of blockchain, it is next. The information that needs to be stored is contained in blocks. Each block has its own hash. It means digital fingerprint that makes the block unique. In addition to information and its hash, the block also contains the hash of the previous block. These blocks are used to create chains that, firstly, cannot be changed, secondly, are stored decentralized. It means that each user has its require validation during each new operation, confirmation of the authenticity of the block, which ensures reliable data protection, while each confirmed record becomes available to all participants at the same time. I want to tell you some words about negative aspects of. Next, I want to say you is that blockchain can be used in legal sphere, and the synthesis of legal sphere and information technologies is smart contracts. This is a program code integrated into the blockchain, which has the form of a self-executing algorithm with certain actions. A smart contract is in legal sense is an agreement between two or more persons to establish, change, or terminate legal rights and obligations, where part of or all of the conditions are recorded and executed automatically using a special computer program. Indirectly, the legal regulation of smart contracts is enshrined in paragraph 3 of the commentaries to the UNIDROIT Principles of International Commercial Contracts. Automated conclusion of contracts is allowed, in which the parties agree to use a system capable of performing self-executing actions, which results in a legal transaction without direct human participation. Highlight that contracts require more detailed legal regulation, including at the national level, since even now, when resolving legal proceedings, the question of recognizing a transaction concluded in. You can't hear me?
Yeah, we had some troubles just maybe for this final part, just to talk a little bit slower, because we had a lot of difficulties with your internet connection. We understood the most part and the crucial point, but maybe just with to slow down to emphasize once more the crucial points of your presentation.
So, okay, I will tell it slower. Now I speak about negative aspects of smart contracts. Firstly, smart contracts require more detailed legal regulation, including at the national level, since even now, when resolving legal proceedings, the question of recognizing a transaction concluded in the form of a smart contract may arise invalid. Secondly, it is likely that difficult to correct errors were made when writing program code for concluding a smart contract. And finally, unpopularity of using smart contracts, which reduces trust on the part of counterparties when concluding it. On the other hand, the use of smart contracts when concluding transactions has a number of advantages. These are high safety and security. Thanks to cryptographic methods for protecting information, all operations specified in the contract are carried out in a secure way, and access to information is strictly limited and securely classified. Moreover, this is fast speed processing, high degree of transparency, decentralization of data storage, and the possibility of concluding a smart contract from different parts of the world without direct interaction between counterparties. Those smart contracts have great potential and many advantages over other methods of concluding civil contracts. Due to their low popularity, the use of smart contracts is still at a low level, although existing cases confirm the effectiveness of their use. And I want to tell you about one of my favorite cases connected to smart contracts. In particular, one of the first smart contracts, which was concluded in 2016 for the purpose of supplying cheese and butter, worth $100,000 to a Seychelles company from the Israeli manufacturer Ornoa. Payment was made using a letter of credit supported by the blockchain. The products were delivered by sea, and the containers were marked with special geolocation sensors. After the ship entered the destination port, a signal was sent to the system. This action meant that the bank could pay the money to the seller. The deal was closed in 4 hours, although under normal conditions, it would have taken about 10 days. In conclusion, I'd like to say that it is worth nothing that smart contracts are just one striking example of the synthesis of information technology and the legal sphere. Digital transformation also affects other areas of law: civil and criminal proceedings, copyright law, environmental law, etc. In the next decade, the basis of a conceptually new understanding of legal relations. Thanks for your attention.
Okay, thank you, Liliya. Unfortunately, we had issues with the internet connection, so on a couple of occasions, but I think we heard the crucial points, and we hope that Cecilia, who is also online and should comment on the paper, also heard the crucial points, has also, of course, read the paper. So because of your problems with internet connection, we understand you couldn't put your picture on, turn the video on during the presentation, but maybe now as Cecilia is presenting her comments, you could, if that's okay with you, turn the video on. And with that being said, I give the floor to Cecilia as the commentator for the 5 minutes comments. Thank you.
Wow, I'm so big, I can see from the screen, but sorry. Thank you for inviting me. It's a great pleasure to be here as a commentator. Thank you, Liliya, hope that is the correct pronunciation, for your presentation. It's very interesting. I'm working on your topic too. And first thing that I want to tell you is don't take my comment personally. So the comments apply to me too. And I'm gonna tell you exactly what my supervisor told me and suggested me when I started my PhD career. So it's completely normal. So the first thing I want to tell you is that it was very difficult to me to understand your paper. And this is primarily because of the language, on the use of English. And what it seems to me is that you wrote the paper in your native language, and then you translated it directly on Google Translator or ChatGPT. But when you write a conference paper or an academic paper, the translators are not so accurate. So you have to use a specific language, which is the academic English, or actually a formal English. And I can suggest you to, for example, use phrase bank, academic phrase banks. For example, you can find on Google, if you search on Google Manchester phrase banks, there are some useful examples of sentences, academic sentences that you can use for your paper. Second, as previously observed by other commentors, the structure. So pay attention to the structure. You only included the abstract, so it was the only part of the paper where I could actually understand what were you talking about, but it was very clear to me, your point. So now you spent half part of your presentation talking about the digitalization of the law, but I thought that main point was the blockchain and smart contracts. So the reader must be able to immediately understand what is the point, what is the problem that under investigation, the issues that you are going to address. So pay attention to the structure. You should include an introduction, the main paragraphs, and the conclusion. Third, references. I know that we were not supposed to focus too much about the formal aspect, but you didn't mention any sort of references, so I wasn't to be able to check the sources and the information, and if they were reliable. So be careful about references, and a little bit about the essence of the paper. So it seems to me that you only divided the paper in 3 parts. The first part was about digitalization, the second part blockchain, and the third part smart contracts. But you didn't say nothing about why blockchain represents a revolution in the legal sector and how it is applied in civil law. You started to talk about blockchain, then you immediately started to talk about smart contracts. So you put the three arguments together, and you didn't explain what is the connection between the 3. So you can say, for example, so far in civil law, blockchain is innovative because it supports the conclusion of new type of contracts, and then you talk about smart contracts. This can be useful. And another comment about the blockchain part, I've noticed that you didn't mention Satoshi Nakamoto, and this is a very big mistake because you mentioned other authors, for example, Tornetta, but the real developer, the developer of the current protocol model of blockchain is Satoshi Nakamoto, and it was in 2008. So you can't write a paper on blockchain without mentioning Satoshi Nakamoto. And finally, and then I will finish, the conclusion. So the conclusion must include a summary of the paper and your personal consideration about it, about the topic. And what you did is just to include a list, a sort of list with point 1, point 2, point 3, and you can't do this in a conference paper. You have to reflect a little bit about about the paper, see what did you find out, and then give your personal reflection about it. And so be careful about that too. Finished. Thank you.
Thank you for your commentator, for your comment. Okay.
Okay, thank you also from here, Cecilia, for the comments, which I'm certain will be helpful to Liliya in improving the paper until the final version. So do we maybe have now some questions or comments from the audience here in person or online? No. Okay. If not, and if Cecilia and Liliya do not have any further comments, I would take the chance to thank them once more for this participation, and to just make a brief comment to the audience relating to the lunch, so that the lunch will start after this session, and we'll be back for the first session in 2:30. So please don't be late for the beginning of the next session. Mila, correct me if I'm wrong. Yeah, that's the schedule. So do we maybe one final question, have some maybe other comments generally relating to this session, or we should go to lunch now for the participants here, of course. We also thank to the participants online who are with us. So something else we would like to add? If not, especially I would like to thank to the authors and the commentators who participated in this session, and see you at 2:30. Thank you.
Okay, I guess we can proceed with the rest of the first day of the conference in English. We have one more session with 2 speakers, of course, 2 commentators. First, we have, and I apologize in advance if I mispronounce the names. First, we have Ashok Kumar Pindiga. Oh, okay, thank you. From the Central European University, who is going to talk on the necessity of regulating artificial intelligence tools in governance, a complex topic. And then we'll have Ahmet Bilal Aytekin. I apologize once more if not correctly. University of Genoa. I saw Ahmet is with us online, so I guess we're all set to go. Ashok, you have the floor. You have 15 minutes.
Good afternoon, everyone. At the outset, I'd like to thank the organizers for giving me on of regulating AI, discussing it from the US and Netherlands. And I've had to talk about AI and social backgrounds of socioeconomic profile of the minorities in US and Netherlands. And part 2, the experience in dealing with AI in both these countries. And part 3 would be about law and the necessity of a legal intervention, and then in my conclusion. Now, to begin with, to folks who are not familiar with AI, so the definition of AI is, algorithm is a set of mathematical instructions or rule that, especially if given to a computer, will help to calculate an answer to a problem. Now, the definition of artificial intelligence system means a software that's developed with one or more of techniques and machine learning and statistical approaches, and can, for a given set of human-defined objective, generate outputs such as content, predictions, recommendations, or decisions influencing the environment they interact with. Now, the big data, which means the application of artificial intelligence, the vast amount of digitized data now available. Now, the sources of data include nearly every piece of information capable of digitization, storage, including internet searches, retail purchases, Twitter, Facebook posts, cell phone calls, highway toll usage, and every last word in the books. Now, according to Professor Dorothy Roberts, she's a professor at the University of Law School, University of Pennsylvania Law School. Now, according to her, so the AI and how it's implemented in the present generation is, it's the ability to apply analytical tools to massive amounts of data collected through sweeping surveillance has radically transformed the nature of predictions. And inequality is embedded in the data already. And according to her, racism is all about predicting. The prediction is even more than it was in the past, and it's a way of maintaining racist social order, making certain racial groups seem as if they are predisposed to certain bad things and justify controlling them. Now, big data analytics is critical to the expansion of carceral regime. Therefore, ladies and gentlemen, I built my presentation on this very theoretical foundation elaborated by Professor Dorothy Roberts. Now, so these are some of the tools used by the police departments in Netherlands and the United States. So the popular in the US is Geopolitica. Formerly, it was known as Predpol. Now, Geopolitica is used to help protect 1 out of every 30 people in the US. The algorithms are written in the pattern that crimes such as burglary and gang violence occur similar to the consequences of an earthquake aftershock. Now, Geopolitica predicts the crime by relying on 3 inputs: historic criminal data, place, and time of crime. And officers on duty are provided printed maps that show 500 into 500 square foot box of an area that they would have to monitor or surveil during the shift. Now, the little red box that you see denotes the high-risk area for the shift. Now, the algorithm is also written in a way that avoids race. Nevertheless, the US cities and towns are highly segregated, pointing to why some neighborhoods experience high incidence of crime than others. The researchers at Gizmodo, which is a non-profit organization based in New York, discovered access to the Geopolitica, formerly Predpol's prediction data to a page on the Los Angeles Public Department public-facing website that contained the data. And so this captured a total of 7.8 million predictions over 70 different jurisdictions. Now, if you just look at the map, which has pink or reddish dots, so those area in a neighborhood that's dominated by African Americans and Latinos. So you have the highest predictions in that area, but you look at the other map, which is completely 97% white neighborhood, and the predictions is 0. So this is one example of how the prediction is flawed when you again combine the previous crime data, which happens in all, normally it takes place in segregated neighborhoods where the minorities are dominant, Black and Latino. Similarly, the police in the Netherlands developed the crime anticipation system in 2017. And then since it's been used in Netherlands, and it's a location-based crime prediction system to assess violent offenders. Now, it predicts 125 into 125 meter crime hotspots. Now, the data again depends on previous criminal history, location, and crime data from the databases of socioeconomic indicators and demographic data from various government departments. Now, this model had a special predictor in initial phases, which is non-Westerners living there. Now, the algorithm was written in such a way as to correlate crime and ethnicity. Now, Western was defined in the program as including most European countries. Now, the input also included the number of social benefits household was receiving and the number of one-person household. Now, another tool that was used in the Netherlands in a small city called Roermond. So it was called the Sensing Project. And but Roermond is a very prosperous town, and it had about 8 million visitors per year. The Dutch police ran this predictive policing project. And so it's about predicting the likely perpetrators of pickpocketing and shoplifting in the shopping centers. Now, an internal study, as well as a independent investigation done by Amnesty International, pointed out that so the Roermond police set out the scope and characteristics of pickpocketing and shoplifting in the city. And the police claim most of the time mobile banditry is committed by persons coming to the Netherlands from the Eastern European countries. Now, the Sensing Project, which is a predictive policing system, uses cameras and sensors placed across the city, across the town, to collect data on vehicles driving in and around Roermond. The Sensing Project, which the police have translated the target profile of pickpockets and shoplifters that fulfill the criteria of mobile banditry into a set of criteria in an algorithm, which alerts the police of possible shoplifters. Now, the criteria and how the algorithm was written is targets, meaning the probable offenders travel by car. The target is accompanied by passengers, meaning the offenders or the burglars travel in group in a single car. And the car takes a specific route, and the car may have a Romanian or German license plate. Car may be white, rental from Germany. And yeah, however, the Roermond police register between 310 and 449 suspects of pickpocketing or shoplifting in the shopping center per year. In the internal study of the police detailed the nationality of the suspects. The number shows that more than 60% of the suspects are individuals of Dutch nationality, and that around 22% of the suspects are individuals with an Eastern European nationality. Now, what this also points out is the biases the Dutch police imbibe. So this is something that percolated into you writing an algorithm, and the algorithm again only helps in predicting only the data that was that went into it. And in May 2016, ProPublica, a non-profit organization in the US, released a research report on Compass. Again, an algorithm-based predicting tool employed in the criminal justice system in the states such as Florida to predict if a defendant would become a recidivist in case if someone is out on a bail or a parole. So now the tool will tell, if this person is going to break the bail bond. But especially for the African Americans and blacks, the predictions were high, so that they could not come out of the prison. But there were very few predictions for the white folks in the US. Now, so that was about policing. Now, and I'll draw your attention to the public welfare and public administration. Now, approximately 30 state agencies in 8 states in the US are using an AI-powered tool known as Fraudcaster, owned by Pondera Solutions, which is again owned by Thomson Reuters. And it's mainly intended to prevent fraud in healthcare and programs such as unemployment insurance and supplemental nutrition assistance program. Now, the platform uses advanced analytics, data integration, and machine learning approaches. The Fraudcaster numerically scores public benefit applicants and recipients based on the purported likelihood of committing fraud, drawing on data from data brokers, social media scrapers, credit reporting agencies, location services, and governmental record databases. Now, the Pondera software makes decisions that dramatically affect people's lives, potentially cutting them off from emergency benefits that they need to remain in their homes and feed their family. But details about how or even whether Pondera software works correctly are extremely difficult to find. There's a lack of transparency about logic underlying Fraudcaster's risk predictions. Pondera, like other private companies, shield their algorithm from public scrutiny, making it very difficult and how they generate the risk score. In Netherlands, I'm told that the Dutch government, it was called CIDI, but it was only ran in low-income neighborhoods. The Dutch court in Amsterdam held that it violates Article 8 of the European Convention for the Protection of the Rights, which is Article 8 is the right to privacy. So, and then if I may conclude just in a couple of minutes. So, risk assessment technology, as Professor Đorđe highlighted, could be according to Lynn, some variations about the risk prediction on the inputs and how the algorithm predicts poverty. So I'm not due to time, I'm not going to other details, but just one easy answer. Risk predicting technology violates all these legal covenants. And then, and how, even though you have the general data protection regulation and you also have ECHR regulations, but how do the states still go about violating by Netherlands and the Germany still have the risk predicting technology in the police? According to Article 8, which is the EU courts accept the prevention of disorder and crime as a legitimate aim without extensive examination. Therefore, the states use Article 8.2 of ECHR to violate the rights, and they do it by justifying that it's necessary for maintaining national security. Yeah. So if you look at the United States, there's a lacuna in laws to deal with AI. You have recently Joe Biden issued an executive order, Title 14110. It's a very comprehensive law, but it is yet to be percolated and to be broken into pieces to deal because now the executive order doesn't tell how will a person be held liable, and then if you be convicted, they do not have anything. So various agencies in the United States have to break it down and fix responsibility. And then coming to the EU, so the EU Artificial Intelligence Act is still being deliberated. But one good thing about the EU Artificial Intelligence Act is it seeks to ban policing, predictions in policing. And then it also would ban facial recognition technology. That's something, but the only problem with the EU artificial intelligence acts is it gives a leeway to the state, where it says that if the military wants to use it for the national security, they can still have the predictive technology. But what I feel is that it can again be a justification. So sometimes these happen in a very secretive manner. We do not know how they would monitor, but still there have to be checks and balances even for that. Yeah, thank you. With this, I conclude. Thank you very much.
Thank you, Ashok. We can proceed with the 5 minutes comment from Ahmed, if he's present.
Yeah, I'm here. Can you hear me?
Yes.
Okay. We are having
can
some
see you.
bad connection. I think I couldn't catch every detail in the last part, but I hope you can hear me. Okay, my general idea about the paper, I know it's a draft, but I think the paper is very descriptive and it lacks novelty and it's not particularly innovative in this message. For more precise comments, for example, the title suggesting the necessity of regulating artificial intelligence tools in governance. So I'm expecting in the paper to see arguments for that necessity. But according to the abstract, this paper argues that using AI in governance and law enforcement reinforces and sustains the unequal social structure and has negative ramification. I think this discussion is already over, and algorithmic bias is in a way is a fact. Everybody knows about it, and that's why we are a European Union developing a AI Act. Biden issued an executive order. So
we're having trouble.
Okay.
Hearing your connection quite bad.
How is it now?
Yeah, I think it's better. Could you please just go back to the previous few sentences?
Okay. The title suggests that you will find arguments for the necessity of regulating artificial intelligence, but I couldn't find very solid arguments beside the existence of algorithmic bias. And the arguments for the existence of the algorithmic bias is already over. We know there is an algorithmic bias, and this shouldn't be the main argument of the research paper now. Maybe in 2016 it could be a great paper, but now it's not original. Yeah, the whole paper in this form, in its draft way, only could be introduction to another argument. So you can use these as an example of algorithmic bias, and you define another problem and give some other arguments. More precise comments, for example, in introduction, it says have proved to be inaccurate. This can be given with a statistic. So it's not 100% inaccurate. It's I don't know, 10% in some apps, 15% for some apps, and 5% for some apps. And these percentages could be acceptable for some applications. For some applications, don't. We don't know that. And another point, I wouldn't mix predictive policing with social welfare and other administrative applications, because the law applicable to these two distinct applications is different. For predictive policing, you use the criminal law theories, and for the other one, you use the administrative law. So for some people, they defend ban of predictive policing, and the same people also can defend the use of artificial intelligence in the administration. So I would divide that two applications into two different papers. Also, I would be careful to use sentences like this essay shall compare the application of AI power tools in governance in USA and Netherlands, as these two countries are leading in AI. For the US could be, but Netherlands is, I don't think it's in even in the top 10 for using AI. So when you use these sort of sentences, always give a source for that or statistics. So the paper could be more credible, I think. And I will jump on the conclusion. Okay, you mentioned the executive order. When I first look at the paper, you said there is no rules, and you say there is no proper legal mechanism to curb this. I mean, could be not. Some people could defend anti-discrimination law is enough for tackling discrimination, just for discrimination, and some people don't. Maybe for some countries this could be the case. So as a general suggestion, I would take this paper and shrink it to the 3-4 pages as an introductory to algorithmic bias and the problem, and then use it for, if you want to do the same thing, I would choose a different country which is not well studied. For example, for Turkey, you can do this and you can examine all the discrimination law, etc. And then you can say, okay, there is no legal document for Turkey to tackle algorithmic bias, so there should be some rules about that. But for Netherlands and the US, it's already known algorithmic biases exist, and they now have some sort of legislation. If you want to focus on that legislation, it shouldn't be 20 pages about algorithmic bias. Again, you give 3-4 pages about algorithmic bias, and the next 15 pages should be about the law itself. I think, yeah, that covers my comments, and it's 5 minutes, I think.
Thank you very much, Ahmed, for the
Thank you for the
excellent
organization.
You're welcome for the excellent and sharp critics and comments. Before Ashok can answer, we can open the floor for discussion, comments, and questions. And of course, these types of criticisms, which are on point and delve into the whole purpose of the paper, are the most useful ones, even if they seem too much at first. But the way to improve a draft paper is in this way, meaning that the best thing you can get is choices. So I open the floor if anyone has comments or questions, both online or in person, before I abuse my role as a moderator to give comments myself. Okay, while you think of something, I'm going to give a brief follow-up on Ahmed's comment, because I've also read the paper, and I think I would agree with most of the things that he said. For me, concretely, this is a new topic, quite interesting, and I haven't had the information that a lot has been written on the biases in algorithms used within these countries concretely. And I guess that nevertheless, there is always some space to improve or deepen one aspect of it. And my general concern here, and it seems to me like a general suggestion we give to people who have recently started to write and don't have too much experience in it, it's always better to focus on one narrow aspect of a topic and then maybe widen it while in the process, rather than give an overview of a huge topic, because it seems to me that you also try to cover a lot. For example, here, it seems to me you use a lot of bias criteria. You try to cover each one of them superficially, at least as much as I saw in the paper. A suggestion would be maybe to focus on one bias, and then what Ahmed said, like connect it to one type of regulation within one country, and not perhaps trying to cover both, especially if you add the novelty aspect, which would encompass research perhaps in a somewhat not that developed area of research in this context. So it's race, property, gender, criminal law. I think you really mentioned a lot of things. And I, for one, as an addition to this comment, would be a concrete question. Would like to hear a bit more on how the algorithm actually works. I don't know if you've researched the concrete application of it. I mean, you mentioned something in the paper, but not that much. Could you perhaps give us a bit more on the actual process of, for example, an application to one case in which we can perceive how the given, I don't know, property or given income to someone who needs it the most, based on the bias algorithm, looks like, and what you think could be a solution for it?
Yeah, so feedback, and I plan to incorporate. Thank you for the feedback and for your comments. I plan to incorporate a large part of it to work on it. This is just a first draft. The AI law in the US is not that developed as such, because probably you could also probably have a look on it, because there's no proper case law on AI as such. And then, so we don't have even case law on the anti-discrimination law, even though provisions exist. So the executive order which Joe Biden just signed, talks about it. So that was probably on 31st of October that he's done it. And even before that, I think if I'm not wrong, in 2022, he also issued another executive order. But those are all broader general guidelines. But we do not have. But what exists is in the states in 2023. So they started having consumer laws now, but we do not have, again, anything to protect the rights in the criminal justice system. So this is some of the, but it's fairly even new even into the US. But even if you look at Europe, it's still not fairly developed, because the EU is still deliberating on it. So so we do not have much of jurisprudence on this. And then why Netherlands is because probably it's only Netherlands that have come across Siri, which also was used in general welfare, like the US, where the states have been using AI tools to predict folks who have been misusing it. But it is just not one. But if, one of the countries that I've looked at even before this was Germany, Denmark, Spain. But you only have one or two. But you look at Netherlands, you have multiple. You could, due to paucity of time, I could not discuss much of them. But you have multiple of them, and we still do not know how many they're still using it. So it is because of that I chose Netherlands and US. Well, and then so coming to your question, was about how engineer have switch law, but so I read a report by the Amnesty International, and how they what they found is what went into making how did the algorithm, what type of algorithm was it, and how did they, what are the things that they got involved in writing the set of instructions. Well, so for the algorithm, so it's just instructions you give, you feed the data. Okay, so you have the previous crime data which the police have. You take that and you write a code. You give the machine the instructions. Look, so it is this set of principles, it is this set of traits, that you need to focus on or you need to trigger. Okay. Now, what the Dutch police have done in Roermann is they've identified the previous traits, the previous profile of the burglars. Now, and again, this is just the bias of the Dutch police, which is that the does travel in a car. So that is one rule. Okay. Also, always and once specific color, which is white, and then the other is Romanian or German. These instructions to be can't see because like the police look, they're traveling. Okay. Now, what the police would do, they would go and stop the vehicle, and then they would search, seize, and whatnot. So this is very broad.
Is there a way to overcome that? Is it the program? It seems to me that the general idea that people are the ones who give criteria to the algorithm.
Yeah. So see, well, again, if I can open my presentation to explain things better, is that fine?
Yeah, you don't have to share it. It's okay.
Okay. So now, so these are the racial disparities in science and engineering education. Now, the one which is dark blue, okay. So the one which is dark blue, so here you have 61% of the workforce who are white, okay, and the African Americans are just 8%. So even if you look at the people involved in writing the codes in the tech industry, it's racially homogeneous. It's about 80%, if I'm not, more than 80 to 90% is just white male who write the algorithms. They are the ones who dominate the science and technology in the US. Now, what African Americans, because they were the most impacted by this. Now, what they argue is the bias of the person who's writing the code percolates it. It's very difficult to have unless and until you have diversity in the workforce. Because, for example, I'll give you another example. Amazon had a AI tool for hiring. Okay. Now, it was rejecting the resumes of women. It was just rejecting the resumes of women, and then Amazon later stopped using that, of what will happen if a certain industry is completely homogeneous by gender or race, So I mean, this is one example because yeah.
Thank you. I think we're even past the time limits. If there are no further questions, and I'll just check with the online participants. Yeah. Okay, so I guess we can give another round of applause for Ashok. Thank you. And move on to the second part of the third session. Just to check. So we have Trong Keep Ding. I again apologize for the pronunciations, and I hope I'm getting this right. I can see that you are online. Yeah. As well as Wang Chi, and I really cannot pronounce the last name, on protecting national sovereignty in cyberspace within the context of digital globalization, regulations of some countries and proposals. And then we'll have Agnes Diaz-Castellano from the University of Genoa as the commentator. So please, Strong, could you take the floor?
Yes, thank you, sirs and madam. And we are so pleased to present here and bring out my presentations about the cyber sovereignties. So at first, could anybody please give me permission to share the presentations?
Yes, just a second. So,
yes, thank you.
Nema.
I will share. Nemam. A ovdje? Ajde promeni grid. Probaj ovaj. Ok, aj sad. Move to
Yeah, you should be able to do it now. Just a second. It's processing. Okay, try now.
Thank you. So
Okay, you're all set.
Yeah, thank you. Okay, so first, my name is Phương Thi Nguyễn. I know it's pronounced quite difficult, but and with my partner is Trọng Hiệp Dinh. We are scholars from Vietnamese University, and we are really pleased to attend the conference today with the topic protecting national sovereignty in cyberspace within the context of digital globalizations. And we also propose some regulations of some country and the proposals. So first we come to the table of contents. I'd like to bring out three main arguments here. The first is not about argument, but the first talking point is about the development of international laws on the cyberspace security and the legal overview of the cyberspace sovereignties. And the second is the different approaches of countries on the protections of cyberspace and the sovereignties. And the finals is solutions for country for safeguarding the governmental sovereignties in the cyberspace. So moving to the first point, as you can see that Mr. Robert Gates, the US Secretary of Defense, in attempt to recommend the US President to establish the United States Cyber Command. He has suggested in 2009 that the next war will begin in the cyberspace. And I'm afraid that that command is coming true because in the most recent war we have seen, like the Russia's and Ukraine war started last year. The Ukraine had been under attack, not always in the traditional ways, but most certainly via cyberspace. And Ukraine government website were hit by the DDoS attack, temporarily taking them down and defaced by a malicious cyber group called UNC 11551. And they assume that it's attacked by the Russian hacker. And that urgency makes us choose the topic about the cyber sovereignty. Sorry, but could you see my slide? Could you still see?
Yeah, we can see it.
Okay. Yeah. Thank you. So back to the history of the international laws, we can see that in the 2001, that is like the Budapest Convention on Cybercrime was established, and it seemed like the only international treaties regulating about the cybercrimes in these areas. However, the UN has always been wondering and concerned about the cybercrime and also the cyber securities all over the world. And in the 2003 and 2005, the UN has adopted the Geneva Declarations of Principle and the Geneva Plan of Actions. The main content of the two documents is outline the principle for promoting inclusive access to ICTs, the freedom of expressions, and the international collaborations. And also, it provides the framework for implementing this principle, focus on infrastructures, access for informations, capability building, the e-governments, and etc. And moving to in the very same near years, in 2004, the UN had established the group of governmental experts on developments in the field information and telecommunications in the context of international securities. And for the most updated, in 2017, the NATO had published the Tallinn Guidelines on International Law applicable to cyber operations. So that is the timeline of what we have researched about the history of the developments of cyber securities and cyber sovereignty in the international law. So coming next, so what is the legal overview of the national sovereignties in the cyberspace? We observe that it's been widely recognized that the national sovereignty is a fundamental concept in international law, and it also applies to the cyberspace. And the United Nations and the Tallinn manuals recognize that the state sovereignty extends to the cyberspace and the cyber operations. And also the sovereignty in cyberspace include authority over the cyber infrastructure, data, and activity within the country territories. And also states have the responsibility to collaborate with each other and not allow their territory to be used for the cyber attack of another state. However, it also brings out that the many challenges when recognize the sovereignty in the cyberspace as the principle in the international law, namely that as the internet infrastructures, it somehow controls like the private companies, and for example, the internet is manifested and developed by many private company and non-state actors, which play a significant role in internet governance, but they're not exempt from jurisdictions or legal accountability. And also the development of AI and the automate decision making in cyberspace can amplify the bias and discriminations. And the overview suggests that the state sovereignty in cyberspace has the inherent limitations, and the cooperation between nations is necessary to address the cyber threat and protect the critical infrastructure. So moving to the next point, we have raised like 2 questions here, and we'd like to discuss further with you in the discussion sessions. But in the next part, we may somehow address the 2 questions. Moving to the next point is the different approaches of the country on the protection of cyberspace. As I previously mentioned, the Budapest Convention, it seems like the only international treaties regulating about the cyberspace matter. So each country, they have developed their own regulations and their own point of view to approach the protection of cyber sovereignty. So first about the United States. Actually, the United States has established several laws or acts regulate about the cyberspace, cyber securities. For example, the Computer Fraud and Abuse Act, the Federal Information Security Management Act, and the Federal Trade Commission Act. However, this law does not touch much on the sovereignty aspect, and as the legislators in the US seems to promote the free and open internet, and they view that there is no need to regulate more detailed or more strictly about the internet, and instead just internet is the global space and the common space in the global area, so that the internet user can freely access. And however, in some speech of the official US US government, you can see that in the 2018 National Defense Strategies, it said that it's only set out the domain preeminence over the land, air, and the sea. That is the traditional sector in the international laws, but not extend to the cyberspace. And also in the national cyber strategies, the President Donald Trump has several times repeat and mentioned the nature of cyberspace is global. It is because the global space is built based on the IP address, the DNS, and the connection within them, and all this is a common result brought out by the internet, but not by any specific government. However, in terms of the sovereignty, the U.S. Cyberscom also recognize that the importance, despite all of this, the U.S. Cybercom recognize the importance of consider the sovereignties of other states in the cyberspace activities, and it promote that the United States can use the cyberspace to protect their own sovereignty. And similar to the United States, the United Kingdom have shared also quite the same view, and they reject sovereignty as the governing principle for the cyber operations. However, they evaluate that international wrongful conduct in cyber operations based on this principle of non-interventions, and the UK can conduct cyber operations in another state territory with the condition that it stays within the boundaries of the non-conventions. And also it's recognized that the prohibitions of the use of force and the right to self-defense in response to the cyber attack. So we see that the UK's view here is quite alike with the mainstream view on the international law on cyberspace, except for extent on the sovereignty. And moving to the Russia has, unlike the United States and the United Kingdom, which do not have like quite a specific law and regulation stipulate the cyber sovereignty, but the Russians and the Chinese, which I will present in the next PowerPoint, they have quite like the strict and the clear view about the cyber sovereignty. And for the Russia, they have established several laws, including data localized law, federal laws, and sovereign internet law, information security law, in which they strongly exert the control over the realm of cyber engineering and the cyber psychologies, which they deem that together constitute the two distinct aspects of the cyber warfare. And they also they want to gain advantages over the adversary and safeguard the vital nation's asset by exercising control over these devices in cybersecurities. And they also have like the strict regulation of censor and manage the informations in the cyberspace within their own territory. And as you may recall, we have like the United Nations had established a group in 2004, but the Russians, what they're trying to do now, they're trying to propose resolutions at the United Nations and create an open-end working group, which is working parallel with the readily existed group of the United Nations to promote their views on the cyberspace. And similar to for the Chinas, they have also enacted several laws to regulate the cyberspace. And most and the most interesting maybe about the Great Firewalls of China, which they impose very strict sanctions on all the, like the Facebook or Google adopt from another country, and they have established like their own word about the Weibo's or the WeChat applications for the citizen to use and to work inside the territories.
Just a reminder of the time, please, if you could,
yes,
in a minute,
thank you.
wrap up. Thank you.
Yeah. So the Asians is also established the Asian cybersecurity corporate strategies, which highlighted the advanced cyber readiness corporations, and which focus on the cooperation within the regionals of Asian to promote the cyber sovereignties. And I would like to skip the slides. And we from the study of the urban legislation and framework and point of view, we have come to the some of the constructing views of the country. You can see that for the Western country and the United States, it seems like they do not support the development of new rules of international law in cyberspace, and they pay special attentions to promoting the applications of rules, responsible state behavior in cyberspace. Yes, states still give the room to promote the free internet. And also they highlighted the importance of state obligation to prevent the malicious cyber activities from taking place within their borders. However, in the China and Russia, they impose more strictly regulations by emphasizing the importance of broad participations of new rules with specific focus on the safeguarding in the interests of developing nations. And they argue that the application of existing rules to cyberspace serve the interests of only for the powerful nations, and thereby they have to promote and they have to lobby for the new principle to apply internationally. So in the last part, we propose some very like the solution, and we really like to discuss more and to invite you to cooperate with us to come up with more practical solutions. So first, we think that we have to enhance because it is a matter of international law, it's not specific for some countries. So the first thing that we have to enhance the collaborations about the technical extent, the counter cyber terrorism, cybercrime, etc., and to enhance the mutual relationship governance between on the internet. And we also have to enhance national capabilities in ensuring the security in the cyberspace by building a network border through collaborations between the military and civil entities. And finally, we have to promote the cybersecurity awareness for the public. It's not about the international law only, it also maybe it's about the IT's area, infrastructures for all the citizens, for the officials, governments to understand, and so that we can have the more freedom place and a more encouraging place to collaborate with each other. So I think that is the end of my presentations, and really thank you for your listening.
Thank you. You may switch off the sharing.
Yeah, thank you.
Now we have Agnes. Very nice to see you. I don't know if you've heard Anna's shouting. Maybe the camera hasn't caught it, but it was quite joyful. So we have 5 minutes, and then we'll have 10 more for a discussion, ending the first day of the conference. The floor is yours.
Thank you so much. No, unfortunately, I didn't hear the shouting, but thank you for the cheering. Well, first of all, I wish to thank the organization of this magnificent event for trusting me to be here today, and also the authors to give me the opportunity to learn and share what I hope is a bit of my knowledge. And I have to apologize because unfortunately I have another meeting, which I think has already started, so I will be quick. So yeah, first of all, for the comments, I wanted to congratulate both the authors because you have done a magnificent job. The paper is very exhaustive and it shows a lot of effort to deep in the knowledge on the issue and showing, which is not always the case, a lot of comprehension of the debate. So I want to congratulate you for that. So that being said, I want to give you some comments. First, I will start with a little formal comments, and then I'm going to move to the substantial ones. So for the formal ones, I'm going to be a bit picky here, but there are little details like the name of the countries. You refer to England, not the UK, or you talk about the EU and you refer to it as a country, which I am sure these are not knowledge mistakes, but in international law in particular, or in this area of science, it unfairly lowers the quality of the paper. The same goes with the citations, which are not always super consistent, which is a problem that I have myself. So this is why I pay so much attention to it. And the abstract, which I think should be a little bit shorter because you add some information there that would be more useful if you add it in the introduction. Then I'm here for a kind of formal substantial comments. You talk about, at the end of the introduction, you mentioned the topic of the research, and the topic, the way it is stated is very vague. You talk about protecting national sovereignty and cyberspace within the context of digital globalization. I think the things that you add in the abstract here would be very helpful. Oh, sorry. Can you still hear me?
Yeah, it's fine. Keep going.
Okay. Something happened and I thought I lost you. Okay. So yeah, the comments that you add in the abstract would be helpful here. Basically explain how you're going to approach this very broad topic, because if not, it looks like it's too broad. Also, the length of the paper, I think it would benefit you if you followed another kind of structure and stick more to the concept of sovereignty. And now I'm moving to the substantial comments. You talk about the sovereignty in cyberspace as the key concept of the paper, but you don't really explain why, or how does the concept of sovereignty apply in cyberspace. This is not too clear, because when you tackle this issue, you start including a lot of information about the feasibility, the different actors, the concerns about artificial intelligence, which of course show that you have a very broad understanding and deep understanding of the complexity of the issue, but it's a bit distracting for the reader. So the point of the sovereignty here gets lost. Something similar happens with other points, like when you talk about the countries, for example, when you talk in specific about the US, you mix a lot of different levels. You talk about different institutions, you talk about NGOs, then you talk about the government. So it's a bit confusing to follow because of the amount of information. So I think there are a few ways in how you could tackle this. Of course, this is very personal. My comment would be just to simplify and incorporate less ideas. I would take one or two existing classifications, like, for example, Benkler's classification about physical infrastructure, code, and content, which you somehow already mentioned in the presentation, and that would help you explain all the complexity that you present in a more clear way. I think it's also very important to better explain the different actors in the issue, because one thing is talking about sovereignty, but as we know, sovereignty in cyberspace looks different than sovereignty in other realms of life, because the actors who play here are not always state actors. So I think emphasizing that is extremely important. And my second substantive comment would be that you assume that international regulation in the broad sense would be positive. I think you have to argue more why that is the case, because maybe not everyone thinks that is so. I think something that was mentioned in the previous presentation, the European Artificial Intelligence Act, the criticism towards it can give you some ideas. And also you don't talk about the existing international law or governance of the internet, which is ICANN, which I think can help you have an overview of how these things have been addressed by international organizations already. All these points are just to make the paper more clear. Most of the content is somehow already there. It's just a matter of structure. And just to finish, I really like the second part of the paper. I think the recommendations are good. I really appreciate the contrasting views. I am not very sure, though, why you separate the countries from the legal framework. It looks sort of repetitive. But I really appreciate how you tackle such a different landscape of countries and how you also incorporate the views of smaller countries and different geographical locations, which I think clearly demonstrates that the problem is global and has a complex nature. And these are all my comments. Thank you so much.
Thank you, Agnes, very much. With this, I open the floor for discussion, possible comments, questions, quandaries.
Just one thing, I'm very, very sorry, but I have to go now. Please feel free to send me an email. I'm very open to have a chat another day or just discuss it over email. I really enjoyed
No problem, no problem. Thank you very much for being with us.
It's been lovely to see you.
Thank you very much.
Bye, likewise.
Thank you.
Okay, yes, Ashok.
Trong, thank you for the presentation. I really enjoyed. So my question is, it stems from the point that you mentioned, which is Russia has comprehensive cyber laws. So, and then you also gave England's experience. So why do you think some states have effective and comprehensive cyber laws, and why some states, even for example, US, why don't they have? And then maybe another point, because since I was working on AI, and then US still doesn't have effective cyber laws to deal with artificial intelligence, and then the problems that are associated with it. And one of the reasons it is because in US, lobbying is legal. So the lawmakers are influenced by the big corporations. So would you concur with my analysis, or would you have some other reason for it?
Thank you.
Just a second. If it's okay with you, we'll collect the questions and then you can collectively answer to all of that, and I respond to Agnes's comment. But first, could you please stop the screen sharing, because we can't see you. While you do that, I would also have a follow-up on what Agnes was saying. It also seems to me that you cover a bit too much within the context of the topic, which is also important from the aspect that Agnes pointed out. It's not that clear what the aim of the paper is, and I think you should have a more detailed and precise account of the hypothesis and the aims you're trying to accomplish within this quite broad and complex topic. So my suggestion, like similarly to Ashok's, would be to maybe focus on one aspect, like either an overview on different regulations, which I think is in general less effective and a good read, because it's the usual. Why am I echoing? The second would be perhaps an assessment of possible solutions, but in a more detailed way than you've done in the draft version of the paper. It seems to me that you can perhaps focus on one example of it again, a case study or one type of regulation within it, or an illustration of what actually the problems within cyberspace encompass. What are the concrete aspects, the goals of countries and other entities that they may have in order to somehow make the topic closer to the reader, because I guess most of the people are new to the topic or don't know that much about it before they read it. And along with all the things that Agnes told you regarding the conceptual precision and the aspects of the concept which you use, which seem to be overlapping in different aspects. So that would be general comments, a suggestion for the improvement. And now, if it's okay with you, you can answer to these addresses.
First of all, I would like to thank you so much for your comments and also for your questions, which will definitely give us more room to finalize our papers. And for the questions about the why, I understand that you have the question about why some country have more like developed the domestic laws over some country like Russia's or China's. I think it is for me it is very difficult to analyze this in a comprehensive way, but I believe that it depends largely on the political views of the countries also, and they have to consider all the pros and cons in the political views. And for the Russians and the Chinese, they kind of have like some reservative views for a long time, and they will continue to reserve their views in the international laws by setting out many rules and many regulations applied on the cyber securities. And I believe that in many other areas. And that is the thing that's coming to my mind now. And I'm sure that I will research more deeper to come up with like the best solution and the best answer in my abilities.
Okay, thank you. Let's give another round of applause. For each of the presentations, of course, each of the comments, discussions, it was excellent. I hope it was also useful to everyone who has participated. And we end the first day of the conference with this. Tomorrow we'll reconceive at 9 o'clock, 9 a.m. So once again, thank you all, and I hope we'll proceed with our collaboration, and that you'll send us the papers in February so that they'll be published as soon as possible. So for those of you who will be here to listen to the second day in Serbian, we'll see you tomorrow. For those of you that will not, thank you for coming and being with us.